So, in this, I will be discussing about cyber laws with respect to Anil K. Nair's notes. So, in his note, he has discussed about 34 topics in his book. So, let's go on with it. Anil K. Nair sir is an advocate of High Court of Kerala. He has provided notes for every law subjects with respect to which is very helpful for law students, and it gives us a basic idea of the subject. And yeah, my personal opinion is that if you're thorough with Alkinas's notes in exam point of view, my opinion is that you will surely get a pass mark. But if you are very keen about the subject and you want to score a very high score, then you should go through other books, the reference books, the textbooks, the case laws, etc. But for an average student, or if it's for the last minute study and you just want to clear the paper, then I would say that Anil K. Nair's notes is very helpful because it is not too lengthy. It's precise and much in a very simple language that we can understand very easily. So let's go on with it. This is notes on cyber laws. So topic 1, introduction. The second half of 18th century witnessed what is now termed as an industrial revolution. As a consequence of industrial revolution, a new set of laws emerged out, the labor and industrial laws. The world today is witnessing a new kind of revolution, the information revolution. It is far more sweeping than any other revolution in history in its reach and influence. It is bringing fundamental changes in all aspects of our life. The information revolution is the outcome of information technology. The information technology, that is IT, is the engine used to drive useful information systems. This includes computers, softwares, internet or intranet, and telecommunication systems. The information technology provides the means for collecting, storing, encoding, processing, analyzing, transmitting, receiving, and printing text, audio, or video information. Today, information technology is not merely a matter of machines and microchips. In fact, now it regulates all aspects of our lives, including how we live, work, communicate, relax, travel, and talk. The future of information technology promises to be more dynamic. Inventions, discoveries, and technologies not only widen scientific horizons but also pose new challenges for the legal world. Information technology has also posed new problems in jurisprudence throughout the world. It has shown the inadequacy of law while dealing with 1. The information technology itself, and 2. The change brought about by the information technology. In order to mitigate the legal problems that arose a consequence of information revolution, laws are enacted by almost all countries in the world. The laws providing answers to the legal problems or dealing with information technology are sometimes loosely referred to as computer laws or information technology laws or simply cyber laws. Now, the Information Technology Act 2000. New communication systems and digital technology have made drastic changes in the way we live. A revolution is occurring in the way people transact business. Businesses and consumers are increasingly using computers to create, transmit, and store information in the electronic form instead of traditional paper documents. Information stored in electronic form has many advantages. It is less expensive, easy to store and retrieve. Further, it is quicker to communicate. Although people were aware of these advantages, they were reluctant to conduct business or conclude any transaction in electronic form due to lack of appropriate legal framework and sanctity. The two main principal hurdles which stood in the way of facilitating electronic commerce or e-commerce and electronic governance, that is e-governance, are the requirements as to the writing and signature for legal recognition. The legal provision assumed the existence of paper-based records and documents and records which should bear signatures. Thus, there was need for giving legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred to as electronic commerce or e-commerce, which involves the use of alternatives to paper-based methods of communication and storage of information. The United Nations Commission on International Trade Law, UNICITRAL, adopted the Model Law on Electronic Commerce in 1996. So, UNICITRAL, that is the United Nations Commissions on International Trade Law, adopted the Model Law on E-commerce in 1996. The General Assembly of the United Nations, by its resolution number 51/162, dated 30/1/1997, recommended that all states should give favorable consideration to the said model law when they enact or revise their laws. India being one of the signatories to it, the Information Technology Act 2000 was enacted by the Parliament in order to give effect to the said resolution. The Information Technology Act 2000 extends to the whole of India, including the state of Jammu and Kashmir. It came into force on 17/10/2000. Please note, it came to force on 17/10/2000. Drastic amendments to the Information Technology Act were effected by the Information Technology Amendment Act of 2008. The amendment came into force with effect from 27/10/2009. Again, the Act was amended in 2017 by Finance Act of 2017, and the 2017 amendment came into force with effect from 1/4/2017. So it was Information Technology Act was enacted in 2000 and came to effect on 17/10/2000. Later, it was amended twice in 2008 and 2017. 2008 amendment came into effect on 27/10/2009. The 2017 amendment came into effect from 1/4/2017. Extraterritorial application. The Act applies to any offence or contravention committed outside India by any person, irrespective of his nationality, if the act or contravention involves a computer system, or computer network located in India. Thus, the Information Technology Act has extraterritorial application. Now, objects of the Act. The following are the main objects of the Information Technology Act 2000. To respond and give effect to the United Nations call to all states to give favorable consideration to model law when they enact or revise their laws, so as to facilitate harmonization of the laws governing alternatives to paper-based methods of communication and storage of information. 2. To provide legal recognition to the transaction carried out by means of electronic data interchange and other means of electronic communication, commonly called as electronic commerce, which involve the use of alternatives to paper-based methods of communication and storage of information. 3. To facilitate electronic filing of documents with the government agencies so as to promote efficient delivery of government services by means of reliable electronic records. The Act aims to facilitate the electronic governance or e-governance. 4. The Information Technology Act 2000 has effected amendment to the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India Act 1934, in order to give legal recognition for transaction carried out by means of electronic data interchange and other means of electronic communication. So, with respect to the objects of the Act, 4 objects were discussed here. One is to respond to the call by the UNICITRAL, of which India was a signatory, for considering the model law. Then, second one was to give legal recognition to the paper alternatives. Then, it was to enable e-filing, that is to facilitate electronic filing of documents with respect to government. And the fourth one was, with this act, there was a sequential amendment in many other statutes for giving legal recognition to the electronic documents, such as the Indian Penal Code, the Indian Evidence Act, Bankers Book Evidence Act, the RBI Act, etc. So, 4 objectives of the Act was discussed, and the Information Technology Act provides for legal recognition of electronic records and digital signatures, authentication and retention of electronic records. The IT Act accords legal recognition to records, files, or documents that are retained in an electronic form. It enables public institutions and government departments to issue electronic license and permits and thus paves the way for electronic governance. The Act establishes the legal framework that will provide for the setting up of a public key infrastructure. The liability of the service providers for third-party content has been clarified. The provisions for the appointment, powers, and functions of the controller of certifying authorities and duties of the subscriber have been provided. The Act prescribes punishment for offences like tampering with computer source document, hacking, and publication of obscene information, etc. So, in addition to the objectives, here what change or what was the effect of the enactment of IT Act 2000 that was discussed here, that it provides legal recognition to electronic records and digital signatures. Then it enabled public institutions and government departments to issue electronic license and permits. So e-governance was made possible, and then public key infrastructure was set up, and the liability for the service providers were clarified and determined. And here the provisions for appointment, powers, and functions of the control of certifying authorities were laid down in the Act. The Act also prescribed the punishment for offences like tampering with a computer source or documents, or hacking and publication of obscene information. So these were all described and laid down by the enactment of this Act. The Act also contained provisions for the establishment of Special Tribunal, Cyber Regulations Appellate Tribunal. So these were laid down by the Act. Now, this is not applicable to some documents and transactions. Let's see what kind of documents and transactions the IT Act was not applicable to. The provisions of the Information Technology Act shall not apply to the following documents or transactions. 1. A negotiable instrument other than a check as defined in Section 13 of Negotiable Instruments Act 1881. The provisions of the Act for the time being in force shall apply to or in relation to electronic checks and the truncated checks, subject to such modification and amendments as may be necessary for carrying out the purpose of the Negotiable Instruments Act 1881 by the central government in consultation with RBI by notification in the official gazette. Now, the second one, a power of attorney as defined in Section 1A of the Power of Attorney Act 1881. Third one, a trust as defined in Section 3 of the Indian Trusts Act 1882. The fourth one, a will as defined in Clause 4 of Section 2 of the Indian Succession Act of 1925. That is actually Section 2 subclause H of Indian Succession Act 1925, where a will is defined. Now 5. Any contract for the sale or conveyance of immovable property or any interest in such property. And 6. Any such class of documents or transactions as may be notified by the central government in the official gazette. So here we have 6 categories of documents and transactions that the IT Act does not apply to. One is Negotiable Instruments Act as defined under Section 13 of Negotiable Instruments Act of 1881. Then Power of Attorney as defined in Section 1A of Power of Attorneys Act of 1881. A trust as defined under Section 3 of Indian Trusts Act in 1882. A will as defined under Section 2 subclause H of Indian Succession Act 1925. Then any contract for the sale or conveyance of immovable property or any interest in such property, that is a transaction. Now the sixth one, any such class of documents or transactions as may be notified by the central government in the official gazette. Now the above documents include disposition of real estate that is commonly required to be in writing almost throughout the common law world. These exceptions will not present any impediment to the growth of electronic commerce. One of those endeavors to study information technology law would find it difficult to understand its provisions in its correct perspective unless he or she has a basic knowledge about the science of information technology and its basic concepts. So it is a highly essential to study the basic information technology such as computer, software, internet or intranet, telecommunication systems, etc. By this, we are going to topic 2. We have a total of 34 topics, and this was the first topic, introduction. Now the topic 2 is definition of computer resources. So with respect to that, Section 2, subclause K of the Information Technology Act 2000 defines the expression computer resources as follows. Computer resource means computer, computer system, computer network, data, computer database or software. Once again, computer resource means computer, computer system, computer network, data, computer database or software. With that, we are going to topic 3, that is definition of computer. The word computer is defined in section 2 subclause I of the Information Technology Act. So computer resource is defined in section 2 subclause K, and computer is defined in section 2 subclause I of the Information Technology Act of 2000. And computer is defined as computer means any electronic, magnetic, optical or other high-speed data processing device or system which performs logical, arithmetic and memory functions by manipulation of electronic, magnetic or optical impulse and includes all input, output, processing, storage, computer software or communication facilities which are connected or related to computer in a computer system or computer network. In the beginning of the civilization, people used fingers and pebbles for computing purpose. In those days, computing needs were very low. With the development of civilization, the computing needs also grew. The need for a mechanism to perform lengthy calculation led to the invention of first calculator and then computers. The term computer is derived from the word compute, which means to calculate. A computer is an electronic machine devised for performing calculations and controlling operations that can be expressed either in logical or in numerical terms. In simple words, computer is an electronic device that performs diverse operations with the help of instructions to process data in order to achieve desired results. The computer has emerged as the most useful machine in recent times. It can perform a variety of tasks like receiving data, processing it, and producing useful results. However, being a machine, the computer cannot perform on its own. A computer needs to be instructed to perform even the simple task like adding two numbers. Every computer needs to be instructed exactly what to do and how to do. Computer works on a set of instructions called computer program, which clearly specify the ways to carry out a task. Without programs, computer would be useless. A computer can only perform what it is programmed to do. Computer is not an intelligent thinking machine. The physical part that makes up a computer are known as hardware. They are input unit, CPU, output unit and the storage unit. So there are 4 components: input unit, CPU, output unit and storage unit. These are all known as hardware. Those are the physical parts of a computer. The input unit accepts data and instructions from the user in a computer acceptable form. The keyboard, mouse, light pen, etc. constitute input unit of a computer. Central processing unit, CPU, is also known as processor. It is the brain of the computer system. This unit performs processing of the instructions and data inside the computer and converts it into meaningful results. The output unit. The output unit accepts the output, which is machine-coded form, produced by the computer, converts them into user-understandable form, and supplies the converted result to the user with the help of an output device. Monitors, printers, and plotters are some of the examples of output devices. A computer system has a storage unit. It stores the input entered through the input unit before processing and stores the result produced by the computer before supplying them to the output unit. The storage unit of a computer comprises 2 memory, primary and secondary. The primary memory, also called the main memory, is the part of a computer that holds the instruction and data currently being processed by the CPU. The intermediate result produced during the course of calculation and the recently processed data. While the instruction and data remain in the main memory, the CPU can access them directly and quickly. However, the primary memory is quite expensive and has a limited storage capacity. Due to the limited size of the primary memory, a computer employs the secondary memory. Floppies, hard disk, and tape drives are some commonly used secondary storage devices. With that, we are going to topic 4, that is definition of computer system. So we looked into the definition of computer resource, then computer resource into subclause K, computer into subclause I, and now we are going to look into the definition of computer system, which is defined in section 2 subclause L of the Information Technology Act 2000. So the definition is as follows. Computer system means a device or collection of devices including input and output support devices and excluding calculators which are not programmable and capable of being in conjunction with the external files which contain computer programs, electronic instructions, input data and output data that performs logic, arithmetic, data storage and retrieval, communication control and other functions. In order to constitute a computer system, the following are the essentials. 1. There should be a device or collection of devices including input and output support devices. 2. Those devices should be programmable and capable of being used in conjunction with external files which contain computer programs, electronic instructions, input data and output data. Third, the device should perform logic, arithmetic, data storage and retrieval, communication control and other functions. So calculators are excluded from the purview of the computer system as they are not programmable and capable of being used in conjunction with external files which contain computer programs, electronic instructions, input data and output data. With that, we are coming to topic 5 with the definition of computer network. So we have gone through a definition of computer resource, then computer and then computer system. Computer resource is defined in 2K, computer into I and computer system into subclause L. Now the expression computer network is defined in section 2 subclause J of the Information Technology Act 2000 as follows. Computer network means the interconnection of one or more computers or computer systems or communication devices through 1. The use of satellites, microwave, terrestrial line, wire, wireless or other communication media, and 2. Terminals or a complex consisting of 2 or more interconnected computers or communication devices, whether or not the interconnection is continuously maintained. So here what is defined as a computer network means the interconnection of one or more computers or computer systems or communication devices. So it can be the interconnection of one or more computers or a number of computer systems or a number of group of communication devices. And it is broken down into 2 categories. Category 1 is the use of through the use of satellites, microwave, terrestrial line, wire, wireless or other communication media. This is the mode of communication between the nodes of in the computer network, that is each system or each communication device is connected through either of this. And the second criteria is terminals or a complex consisting of 2 or more interconnected computers or communication devices, whether or not the interconnection is continuously maintained. Topic 6. Definition of communication device. The expression communication device is defined in section 2 subclause HA of the Information Technology Act of 2000 as follows. Communication device means cell phones, personal digital assistants or combination of both or any other devices used to communicate, send or transmit any text, video, audio or image. So the expression communication device is defined in section 2 subclause HA. So we went to the definition of computer resource in 2 subclause K. Then what is a computer network? A computer network was defined in 2 subclause. What was a computer is defined in 2 subclause I. And then we came into a computer system, which was defined in 2 subclause L. And then to computer network, which was defined in 2 subclause J. And now we have what is a communication device, that is defined in 2 subclause HA. So a communication device means cell phones, personal digital assistants, that is PDAs, or combination of both or any other device used to communicate, send or transmit any text, video, audio or image. So that is called a communication device. So what kind of communication? It can be to communicate, send or transmit. And what kind of data? Can be text, video, audio or image. And what are these devices? This can be either cell phones or PDAs or a combination of both. So with that we are coming to topic 7, that is definition of data. So data is defined in section 2 subclause O of the Information Technology Act. So by this definition, data means a representation of information, knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed or has been processed in a computer system or computer network and may in any form, including computer printouts, magnetic or optical storage media, punched cards, punched tapes, or stored internally in the memory of the computer. So in short, it means any kind of information, knowledge, facts, concepts or instruction, etc. And how are they available? They are available in a computer system that can be internally internally stored, or some computer printouts or magnetic or optical storage media, or using punch cards or punch tapes. So all those things are called data, and it is defined in section 2 subclause O of the Information Technology Act 2000. Now to topic 8, definition of computer database or software. So the expression computer database is defined in explanation 2 to section 43 of Information Technology Act. So far all the definitions were given in section 2, that is computer was given computer resource in 2K, and what a computer is was discussed in 2I, and then computer network was discussed in 2J, and computer system in 2L, computer network in 2J, and communication device in 2 subclause HA. So all these definitions, data in 2 subclause O, so all these definitions were under section 2. But computer database or software, that computer database is the keyword used in the act, and that is defined in explanation 2 to section 43 of the Information Technology Act 2000. And the definition is as follows. Computer database means a representation of information, knowledge, facts, concepts or instructions in text, image, audio, video that are being prepared or have been prepared in a formalized manner or have been produced by a computer, computer system, computer network, and are intended for use in a computer, computer system or computer network. So what kind of database is this? So it can be either a information, knowledge, facts or concept or instruction set. And in which format this may be in? It can be either in a text or image or audio or video. And this particular may be already processed by a computer or is intended to be processed by a computer. Now, Now, a computer system consists of hardware and software. Hardware consists of electronic devices that are capable of computing and manipulating information. Software is a set of data and instructions that carries out predefined tasks to complete a given job. So that is the difference between the hardware and software. Hardware consists of electronic devices that are capable of computing and manipulating information, whereas the software is a set of data and instructions that carries out predefined tasks to complete a given job. A computer cannot think or perform on its own. It performs operations like addition, subtraction, manipulation, and division only when the user instructs it to do so. The user gives instruction and the central processing unit, that is the CPU, acts in accordance with these instructions. The set of instructions which control the sequence of operation are known as programs, and collectively the programs are called software. So the set of instructions which control the sequence of operation is known as programs, and the collection of these programs is called software. It is an intangible commodity, that is the part of the computer system that the users cannot touch. We can equate hardware and software with human body and human intelligence respectively. All human actions such as walking and eating are based on the thoughts and feelings which are raised by brain. If the brain does not raise thoughts and feelings, we do not perform any physical activity. Similarly, the actions and functions of every hardware equipment are driven by software. Software is a generic term for organized collection of computer data and instructions. It is responsible for controlling, integrating, and managing the hardware components of a computer to accomplish specific tasks. In the field of information technology, the word software is used to denote collection of data and instructions in a computer. Now to topic 9, that is definition of information. So the word information is defined in section 2 subclause V of the Information Technology Act. Now, how is information defined? Information includes data, message, text, images, sound, voice, codes, computer programs, software, and databases or microfilm or computer generated microfilms. So this is an inclusive definition, and it is given in 2 subclause V of the Information Technology Act. Now topic 10 is definition of function. The word function is defined in section 2 subclause U of the Information Technology Act. Function in relation to a computer includes logic, control, arithmetic process, deletion, storage and retrieval, and communication or telecommunication from or within a computer. So what does functions include? It include logic, control, arithmetical process, deletion, storage and retrieval, and communication or telecommunication from or within a computer, and it is defined in 2 subclause U. Now topic 11 is the definition of computer contaminant. The expression computer contaminant is defined in explanation 1 to section 43 of the Information Technology Act. So we already discussed about explanation 2 of section 43, and that was the expression computer database. So the explanation 1 of section 43 discuss about computer contaminant. So how is it defined? Computer contaminant means any set of computer instructions that are designed A. to modify, destroy, record, transmit data or program residing within a computer or computer system or computer network. So what is discussed here? It is modify, destroy, record, transmit data or program within a computer or computer system. That is part A. Now part B, by any means to usurp the normal operation or disturb the normal operation of the computer system or computer network. So the definition has 2 parts. One is an action and one is the intention behind it. So the action is modify, destroy, record, transmit data or program residing within a computer system or computer network. Mainly the action is transmit, modify, destroy, record and transmit. So the intention should be to usurp the normal operation or disturb the normal operation of the respective computer or computer system or computer network. Now, the topic 12 is the definition of computer virus. So, yet again, we have section 43, that is the explanation 3 of section 43 that defines computer virus. So, computer contaminant, computer database, and computer virus is explained in the explanations or defined in the explanations of section 43. Explanation 1 of section 43 deals with computer contaminant. Explanation 2 of section 43 deals with computer database. Explanation 3 of section 43 deals with computer virus. So, computer virus means any computer instruction, information, data or program that destroy, damage, degrade or adversely affect the performance of a computer resource or attach itself to another computer resource and operates when a program, data or instruction is executed or some other event takes place in that computer resource. So here also there is a two kind of classifications of act. One is to directly affect the computer network or system, and one is to indirectly affect. So direct effect is destroy, damage, degrade or adversely affect the performance. And what will be the indirect effect will be when it attaches itself to another computer resource or operates when a program or data instruction is executed or some other event takes place. Now, now we have topic 13, that is with respect to computer source code. So, this yet again is defined in the explanation 4 of section 43 of Information Technology Act. Computer code means the listing of program, computer commands, design and layout and program analysis of computer resource in any form. Okay, so yet another addition to section 43 explanation, that is computer source code. So that is with topic 13, and topic 14 is definition of damage. That is yet again as defined in explanation 4 of section 43 of IT Act. Damage means to destroy, alter, add, modify or rearrange any computer resource by any means. So computer source code is explanation 5 of section 43 and damage is defined in explanation 4 of section 43. With that, we are coming to the end of this segment and the rest will be discussed in the next segment. This is the second segment of the AKN Sir's note regarding cyber law. So here we are starting with topic number 15 out of the total 34 topic, and in topic number 15 it's about definition of access. So the word access is defined in section 2 subclause A of the Information Technology Act 2000. Access means gaining entry into, instructing or communicating with the logical, arithmetical or memory function of a resource of a computer, computer system or computer network. So here it is gaining entry into, instructing or communicating with the logical, arithmetical or memory function of a resource of a computer, computer system or computer network. Going further, topic number 16, the internet. The internet is the world's largest computer network made up of thousands of networks worldwide. It is the worldwide systems of computer networks which allows the participants to share information. The foundation of internet was laid in 1969 by the Department of Defense of United States of America. They wanted to create a computer network that could continue to function in the event of a disaster such as nuclear war. Even if a part of the network was destroyed or damaged, the rest of the system would continue to work. The network was known as Advanced Research Projects Agency Network, that is ARPANET, ARPANET, that is Advanced Research Projects Agency Network. which linked US scientific and academic researchers. It was the forerunner of today's network. Later, in 1980, another agency, the National Science Foundation (NSF), created a new network of computers based on ARPANET called NSFNet, which turned out to be more efficient and capable. Initially, NSFNet was designed to link 5 supercomputers situated at major universities of NSF and allowed only academic research. Over the time, this network expanded to include sites for business, universities, governments, etc., and finally becoming a network consisting of millions of computers, now known as the Internet. In the 1980s, Usenet newsgroups and electronic mail, email came into picture. Internet really became popular in the 1990s after the development of the World Wide Web, that is WWW. Before that, it was open for a handful of sites only. By June 1993, there were only 130 websites. Now, there are millions of websites. The Internet today is a repository of every type of information. Now, an Internet user can get all sorts of information ranging from choosing a product for personal use to the design of a functional spaceship. Now, Internet related terms. The first one will be World Wide Web, that is WWW, or we can also call it as web. Now, WWW, World Wide Web, is a collection of linked documents or pages stored on millions of computers and distributed across the world. WWW is the most popularly used Internet subnetwork. It provides information in multimedia form, that is in more than one medium such as text, graphics, video and audio. Further, it provides a simple and consistent way of accessing the information available on the Internet by using the hypertext system. In hypertext system, the documents are connected to the other related documents on the Internet through links. The web uses a specific Internet protocol called the HTTP, that is Hypertext Transfer Protocol, to support the hypertext documents. Now, the second term we discuss here will be web page. The hypertext documents on World Wide Web are known as web pages. In other words, a web page is a document on the WWW which is created with HTML, hypertext markup language. The web pages are linked together through hyperlinks, which enables the user to jump from one web page to another by clicking on a link. Now, the third term we discuss here is website. The website is a set of related web pages and they are linked through hypertext links. These pages are published by an organizer or an organization or an individual. All the websites on the Internet constitute the WWW. Now, the fourth term we discuss here is the home page or index page. A home page or index page is a starting point or a doorway to the website. It refers to the web page that identifies the website and contains the hyperlinks to the other websites in the website, other web pages in the website. And then we have the fifth term, which is web browser or simply browser. A web browser is a special software that enables user to read or view web pages and jump from one web page to another. It is a software that is needed to find, retrieve, view and send information over the Internet. And the sixth term we discuss here is URL, Uniform Resource Locator. Each web page has a unique address called a URL, which identifies its location on the Internet. Usually, the format of a URL consists of 4 parts: protocol, name of web server or domain name, path and a file name. Here is an example: http www.bbc.co.uk news. Here the protocol is HTTP. Web server name or domain name is www.bbc.com, and the path is news. And here, if there is a if the URL ends with a title.html or htm, that will be the file name. Please excuse me. So, as the example of URL, we discussed www.bbc.co.uk. That will be the domain name, and the path will be news business, and it will end with the file name. Now, going further, there is internet applications. An internet user has access to a wide variety of services such as email, file transfer, vast information resources, interest group membership, interactive collaboration, multimedia display, real-time broadcasting, shopping opportunities, and much more. Looking into each of it, first we will be discussing about email, that is electronic mail. Electronic mail or email is a fast and easy way to communicate with other internet users around the world. It is not only one of the earliest services of the internet, but also the most used application on the internet. Each user of email has a mailbox address to which messages are sent, and the mailbox can be accessed from anywhere and at any time. Electronic mail can also be used to send documents, images, audio, and video as an attachment along with the mail. Now, FTP, File Transfer Protocol. The File Transfer Protocol is a set of rules that enables a user to transfer files from one system to another. It was first service developed for the internet so that the government and educational institutions could easily exchange the files. It allows the user to get access to the rules stored in the directory of a remote computer that is connected to the internet. Using FTP, one can upload and download files from the remote computer if he or she has access permission in the remote machine. Though files can be transferred by using email, this is not a good choice if the file size is large or when there are many files. FTP sites can consist of hundreds to thousands of files with information on books, music, software, games, images, sounds, multimedia, courseware, etc. Then came Telnet. Telnet is a protocol that allows a user to log on to a remote computer. It is also known as remote login. It connects the user machine to another in such a way that the user may interact with another machine as if it is being used locally. Thus, a person in Trivandrum can connect to a computer in New York City Public Library and search the card catalog in the same way as someone located at a terminal in the library can do. In order to avail this facility, the Telnet client computer must run a Telnet client application, and the Telnet server must run a Telnet server application. Moreover, the user's machine has to be connected to the internet or a network in order to use Telnet. Telnet does not have file transfer capability. It can only be used to access information, run programs, and edit files with the help of certain Telnet commands. Now, Internet Relay Chat, IRC. Internet Relay Chat is a service on the internet that allows people to communicate in real time and carry on conversation via the computer with one or more people. It provides the user with facility to engage in simultaneous online conversation with other users from anywhere in the world. Then we have chatting and instant messaging. Chat programs allow users on the internet to communicate with each other by typing in real time. A chat room is a virtual meeting room where computer users can communicate with each other in real time. People from all over the world can come together in a chat room to discuss the topic of mutual interest. As chat programs allow users on web to contact other users currently logged in by typing conversation, it facilitates instant messaging. To avail this internet service, the user must have software called Instant Messenger installed on the system. Internet telephony. Internet telephony is the use of internet to exchange spoken or other telephonic information. It consists of hardware and software that enables people to use the internet as a transmission medium for telephone calls. Video conferencing. It is a form of meeting in which participants in remote locations can view each other and carry on discussion via web cameras, microphones, and other communication tools. It enables direct face-to-face communication across networks. It may be person to person, which is referred to as point to point or P2P, or may involve more than two people, referred to as multi-point. And the video conferencing terminals are often referred to as endpoints. Now there are newsgroups or Usenet. Newsgroups are international discussion groups that focus on a particular topic and helps in gathering information about that topic. The topic discussed here cover all the fields such as politics, computer technology, and many more. The information on articles that make up the news are written by people interested in a specific topic. These articles are posted to the newsgroup so that others can read, reply, and comment on them. To read and post articles in a newspaper, newsreaders software such as Microsoft Outlook, Express, or Netscape News is required. Most newsgroups exist on a network known as Usenet, which contains thousands of newsgroups. Now, mailing list or list server. Mailing list enables people with similar interests from all over the world to communicate and share information with each other. There are hundreds of mailing lists, each for a different subject. The mailing list group are administered by a software program known as list server. When a user subscribes to a list server, messages from the other subscribers are automatically sent to his email. A mailing list or list server can bring people together with a common interest. Now, commerce through the internet or e-commerce, or you can say electronic commerce. The word e-commerce is used to denote trade, that is buying and selling of goods and service, and aids to trade, that is communication, advertisement, transportation, insurance, fund transfer, and so on. Thus, we may say commerce is the sum total of all the processes which are necessary to remove hindrance in making exchange of goods and service as possible. Electronic commerce or e-commerce is a way of conducting commercial transaction over the internet or any other form of network. E-commerce refers to buying and selling of goods and services online. Through the development of e-commerce, the internet has established an electronic global market that operates 24 hours and 365 days a year. Organizations and individuals are able to market goods and services by secure facilities such as digital signatures, which is a process that ensures authenticity of message source and integrity, and encryption, which is a method of ensuring data secrecy. Now that was with topic number 16 about internet. Next we have topics number 17, that is authentication of electronic records or digital signatures and electronic signatures, or discuss the legal provisions relating to the authentication of electronic records by affixing digital signature and electronic signature. So this is our topic number 17. Chapter 2, that is sections 3 and 3A of the Information Technology Act 2000, deals with the authentication of electronic records by digital signature and electronic signature. These sections, other related sections and relevant rules are given at the end of this topic under the subhead Law relating to authentication of electronic records by affixing digital signatures and electronic signatures. Now, introduction. The general rule is that the law does not prescribe any particular mode of execution of commercial transaction or contracts for their enforceability through court of law. However, in exceptional situations, law expressly provides that a commercial transaction or contract should be in writing and signed by the parties to it so as to be enforceable. This document is the record of the agreement, and the signature is a stamp of a person's identity and marks his intention to commit himself legally. The commercial community has found these two requirements convenient to create legal relationship and has become a well-established mode of executing business transactions or contracts. The requirements of writing and signature perform a variety of functions. The parties documenting their commercial relationship have a confidence that 1. A permanent record of their transaction has been created. 2. It would not be unilaterally altered. 3. It would facilitate reproduction. This document becomes a tangible evidence of the existence of a contract. It would also give evidence to show the real intention of the parties who executed it. When a person puts his signature on a written document, he establishes a link between himself and the document and thus authenticates it. Signer, by virtue of his signature, is identified with the document. The signature on a document is not only a stamp of a person's identity, but also implies approval on his part to the contents of the document. The writing itself may not sometimes be sufficient to reflect assent of the party. The signature demonstrates willingness on the part of the signer to be a part and parcel of the deal. The signature symbolizes the finality of the deal. It marks the consensus ad idem of the parties, a sine qua non for every commercial transaction that is a contract. It brings certainty and clarity in the transaction. Traditional methods of communication of information for executing a commercial transactions or contracts have considerably changed. The information available on the internet can be used differently and has much more utility than the information contained in the paper form. The new mode of communication of information has not changed the basic nature of the transaction but only its form. Law has to adapt to these changes. Together with the business community, law has to evolve rules and practices which ensure reliability and validity. The electronic means of communications do not have any tangible medium. Thus, affixing of parties' signatures on something that is not physically or tangible is not possible. The solution lies in affixing electronic signature on an electronic record. Like written signature, electronic signature can be used to establish the identity of the party who signed the document or as a proof of his intention to commit himself to the deal. A special form of electronic signature known as digital signature can be used to guarantee that the electronic document which has been signed by way of electronic signature has not been altered or tampered with. Authentication of electronic records. Every user of the internet, whether he is an originator or addressee, always concerned about the security, confidentiality and integrity of the electronic record, and its authenticity is the concern of the addressee. And this person interested in executing commercial relationships, that is creation of contracts over internet, will always be particular about the following matters or following subjects. 1. Who sent this message? 2. When was it sent? 3. To whom was it sent? 4. Was it received? 5. When was it received? 6. Did it arrive in the same form in which it was sent? 6 was did it arrive in the same form in which it was sent? And 7, has it remained confidential? And the information transferred over the internet passes through various intermediate stations, and anyone who is interested in knowing the information can intercept it. Messages that are sending through an email or other mode are prone to forgery, as it can be moderated, changed, or made to appear as if it were coming from a non-party with that party's knowledge and consent. When the internet is used as a medium of communication, neither physical document is created nor any original document is exchanged between the parties. Sometimes parties do not see each other. There is a genuine desire of each party that the other party may not repudiate the party's action. The authenticity, integrity, and non-repudiation of the message, which are three essentials of a record to form legal basis of a claim, can be achieved by the different encryption methods. This includes digital as well as electronic signature. A person who wants to send a message or electronic record can authenticate the message or electronic record by affixing his digital signature or electronic signature. By Section 3 of the Information Technology Act, a subscriber may authenticate an electronic record by affixing his digital signature. By Section 3A subclause 1 of the Information Technology Act, a subscriber may authenticate any electronic record by electronic signature or electronic authentication technique which is considered reliable and may be specified in the second schedule. Now, digital signature. Digital signature uses public key cryptography technique, which employs an algorithm using two different but mathematically related keys, one for creating a digital signature or transforming data into seemingly unintelligible form, and another key for verifying the digital signature or returning the message to its original form. Computer equipment and software utilizing two such keys are often collectively termed as an asymmetric crypto system. The complementary keys of an asymmetric crypto systems for digital signatures are termed as the private key and the public key. The private key is known only to the signer and is used to create the digital signature. The public key is ordinarily more widely known and is used by a relying party to verify the digital signature. If many people need to verify the signer's digital signature, the public key must be available or distributed to all of them. Although the keys of the pair are mathematically related, if the asymmetric crypto system has been designed and implemented securely, it is computationally infeasible to derive the private key from the knowledge of the public key. Thus, many people may know the public key of a given signer and use it to verify the signer's signature, but they cannot discover the signer's private key and use it to forge signature. Another fundamental process termed as hash function is used in both creating and verifying a digital signature. A hash function is an algorithm which creates a digital representation in the form of a hash value. Further of digital signature will be discussed in next segment. As it is, digital signature is an important topic, so I'll be doing digital signature in single go in next segment. Thank you. So another fundamental process termed as hash function is used in both creating and verifying a digital signature. A hash function is an algorithm which creates a digital representation in the form of hash value of a standard length, which is usually much smaller than the message but nevertheless substantially unique to it. Thus, use of digital signature usually involves two processes, one performed by the signer and the other by the receiver of the digital signature. A digital signature can be identified as short unit of data that bears a mathematical relationship to the data in the document's context and provides assurance to the recipient that the data is authentic. It is a mode of authentication of any electronic record by a subscriber by applying asymmetric crypto system and hash function. which envelops and transforms the initial record into another electronic record. Working of digital signatures. Cryptography is a mathematical application which is used to encode as well as decode a message. A plain message, also called as plain text, is encoded and converted into a coded message called ciphertext. The ciphertext is decoded and converted back to plain text. Encoding is also called encryption and decoding as decryption. This encryption is possible either by symmetric cryptosystem or by asymmetric cryptosystem. The symmetric cryptosystem, as the name suggests, use a single key, which may be shared by the sender and the recipient of the information has the same key as encrypts as well as decrypts the message. So the same key is used for encryption and decryption, and the same key is given to the sender as well as the receiver. As against this, asymmetric cryptosystem, that is also known as public key cryptosystem, uses two different but mathematically related keys. One key is called the private key and the other one is called the public key. Every person who wants to transmit his or her message over the internet by using asymmetric cryptosystem must have two keys. The private key has to be secret, and if one loses its control, which in technical language is called compromise, it makes information vulnerable to interlopers. The public key has to be made available to the public. In public key cryptography, as stated above, encryption keys come in pairs. Each key of a key pair is different from the other, although the keys are mathematically related to each other. The mathematical relationship between the keys is such that the following holds true. 1. Data encrypted with one encryption key can also only be decrypted with the other key of the pair, which means that the data encrypted by private key will be decrypted by the public key, and data encrypted by the public key can be decrypted by the private key. This is known as two-directional function of a public key algorithm or reversibility function. So, data encrypted with one encryption key can only be decrypted with the other key of the pair, which means the data encrypted by private key will be decrypted by the public key, and data encrypted by the public key can be decrypted by the private key only. This is known as two-directional function of public key algorithm or reversibility function. If the length of encryption key measured in bits is sufficient, it will be practically impossible for anyone in possession of one key of the key pair to determine the other key. That is the second thing. So only if both holds true, the public key cryptography can be effective. Now, a digital signature is created by the private key and is verified by the other, that is the public key. If many people need to verify the signer's digital signature, thus public key must be available or distributed to all of them by publication in an online repository or directory where it is accessible. Although many people know the public key of a given signer, of a particular signer, and use it to verify the signer's signature, they cannot discover the signer's private key and use it to forge digital signature. Digital signature can be created as well as verified by mathematical function known as hash function. A hash function is an algorithm which creates a digital representation or fingerprint in the form of a hash value or hash result of a standard length, which is usually much smaller than the message but nevertheless substantially unique to it. Any change to the message invariably produces a different hash result when the same hash function is used. In case of a secure hash function, sometimes termed as one-way hash function, it is computationally infeasible to derive the original message from its hash value. So, secure hash function is also termed as one-way hash function, and it is computationally infeasible to derive the original message from its hash value.
The hash value is unique to the message, and it is difficult to produce the same hash value from another message by applying the same algorithm. If the message is slightly changed, it produces entirely different hash value. It is not possible to derive the contents of the message from hash value. Thus, the digital signature authenticates both signer as well as document. Digital signature accomplishes three important characteristics of a signature. First, digital signatures provide an assurance that a message has in fact come from its purported sender. First, digital signatures provide an assurance that a message has in fact come from its purported sender. This assurance supplied by a digital signature is called proof of origin or data origin authenticator. So, proof of origin or data origin authentication. Second, it enables a recipient to verify that a message has not been intentionally or accidentally altered, a quality known as message integrity. Third, no one but the purported sender could have sent the message, a quality known as non-repudiation. So, digital signatures are used to accomplish these three important characteristics, that is, data origin authentication, then message integrity, and non-repudiation. So, digital signatures in practice. Suppose Rama and Sita wish to exchange email message over internet, and they wish to have a high degree of assurance that the message which they wish to exchange are authentic and would remain confidential. Both of them have personal computers on which email software and public encryption software have been installed. They have generated an encryption key, public key and private key, and kept private key secret, whereas public key is widely made available by publication in an online repository or directory where it is easily accessible, is exchanged with each other. Once the exchange of keys is complete, Rama will have his own key pair as well as Sita's public key, and Sita will have her own key pair and Rama's public key. Here it may be made clear that when public keys are exchanged, the exchange does not take place in physical sense as we understand by the exchange of tangible keys. Private key as well as public key is nothing more than the particular data. The exchange of public keys takes place when the other party knows it. Rama intends to send a message to Sita. Please see me in college at 10:30 a.m. Rama has a choice here. He may encrypt the whole message for a privacy reason or simply append his digital signature for authentication purposes, or both. So let's discuss both scenarios separately. Suppose Rama wants to maintain only confidentiality of the message and is not interested in appending digital signature. Rama will encrypt message M with Sita's public key to get ciphertext EN. This will be transmitted to Sita. Since Sita's public key has been used, she can decrypt with her private key. The message will remain confidential as the ciphertext produced is an unintelligible data, meaningless for all those except Sita. Sita alone can decrypt it and can get meaningful message. That is, please see me in college at 10:30 a.m. Similarly, if Sita wants to send a message to Rama in the same way as Rama sent her, she has to encrypt the message with the public key of Rama, and the message will be decrypted by Rama alone with his private key. In the above situation, only confidentiality is maintained. Anyone other than Rama can encrypt the same message by the public key of Sita. Sita, on decrypting the message, will not be sure about the authenticity of the message, which can be achieved as follows. So now, where there is confidentiality and authentication. Now suppose Rama wants that Sita be sure that the message has come from him only, which is in the technical language is called authentication, and has not been altered in the course of transit. He is not interested in maintaining its confidentiality. Rama will take the message M as input to produce a smaller digest or message summary in the form of numbers. Example 43591. that it 4359 that it called hash value. The number is unique to the message of Rama. Any change made by any person in the message will produce altogether different hash value. Rama uses his private key to transform hash value into digital signature CM as against public key with which Rama applied for maintaining confidentiality of the message. Then he appends digital signature to his message. Thus he sends her plain message M with the digital signature appended. If Sita wants to send message to Rama, then she has to use a private key instead of the public key which she used for sending confidential message and apply the same process as applied by Rama. Now suppose Rama wants both confidentiality as well as authenticity of the message. Okay, he is not interested in anyone else knowing his message and also wants to give confidence to Sita that no one he alone has sent this message and the message has not been altered during transit. Rama will now apply encryption software program. The encryption software makes message M and distills the hash value of it using an encryption algorithm as above in the case of authentication. Suppose hash value of the message "Please see me in the college at 10:30 am" is 43591. The software then encrypts the original text message M using Sita's public key. It then transforms hash value with Rama's own private key and obtains digital signature. The resulting digital signature is unique both to the message and the private key used to create it. A digital signature, digitally signed hash result of the message, is attached to its message and stored or transmitted with its message. However, it may be sent or stored separately so long it maintains a reliable association with its message. The digital signature being unique to a message, it will not serve its function if it is wholly disassociated from its message. Once the digital signature is created, the encrypted message together with the digital signature is sent to Sita over internet. Hash value of Rama's message can be decrypted by anyone who is possessing Rama's public key, but by getting hash value of a message, one cannot get the contents of the message. The contents of the message have been encrypted by Rama with public key of Sita, so Sita alone can decrypt the message with her own private key. Sita receives the message in due course. Like Rama, Sita's computer has an email program which is integrated with the encryption program. When Sita attempts to read Rama's message, a number of things are possible. Sita is asked to supply passphrase for her private key, which she supplies. Using Sita's private key, the software then decrypts the message and obtains "Please see me in the college at 10:30 am." Now Sita wants to be sure that the message has come from Rama. She requests the program to verify digital signature. The encryption software in Sita's computer first takes the message "Please see me in the college at 10:30 am" and distills its hash value by using the same hash algorithm which has been used by Rama's computer. The message yields a hash value of 43591. The software then uses Rama's public key and decrypts the hash value of the message, which is also 43591. The two hash values are then compared and found to be identical. The software then displays on Sita's computer screen a message that reads "Good digital signature from Rama" or simply "Verified." As a result of the basic principle at play in asymmetric cryptography, it is possible to conclude in the above example that the message sent by Rama to Sita is authentic and has not been changed en route for the following reasons. 1. The hash value was successfully recovered using Rama's public key. Only Rama's private key known to him could produce the message. Hence, the message is reliably known to have come from Rama. Third, the hash value received from Rama exactly matched the hash value calculated from the message. It is certain that the message has not been altered in transit. The process of creation and verification of digital signatures accomplish essential attributes of signatures that are necessary for various legal purposes. When it is established that a key pair belongs to a particular person, the digital signature identifies the message with the person. There is no possibility of forgery of digital signature unless the private key holder loses the control of the key by either himself divulging it or losing the medium or device in which it is contained. The digital signature also ensures message integrity with far greater precision and certainty than paper signature. Since slight change in the message will result in altogether different hash value, so comparison of hash value establishes beyond doubt whether the message is the same as it was when signed. Once digital signature is created, it will be presumed that the signer created the signature with a full sense of realization that the legal consequence will entail by executing transaction. In other words, digital signature is manifestation of his approval to the transaction. However, this approval is undermined when an autonomous computer is online, because in such cases the person is signing the message will not be a human being but a device under the control of human being. The digital signatures, beside ensuring high level of genuineness, are inexpensive as against its paper-based counterpart, as both creation and verification is an automatic process with little human intervention. The digital signature yields a high degree of assurance without adding greatly to the resource required for processing. In addition to the authentication of data by digital signatures, there exist other technologies as well by which data can be authenticated. For instance, electronic signature is designed in software which enable users to manually sign digital record using stylus on a pen enabled computer screen or on a digitalized tablet. Biometric techniques are used in such systems to measure exactly the attribute of a handwritten signature. The digital record, the digitization image of the manual signature, the user's identity profile, and handwriting analysis are then bound together using cryptographic techniques so that this user's signature, their profile, and their signature authenticate the document. And thus we will be moving forward to electronic signatures. By Section 3A, Subclause 1 of the Information Technology Act 2000, a subscriber may authenticate any electronic record by electronic signature or electronic authentication technique which is considered reliable and may be specified in the second schedule. Now, the term electronic signature is used to denote all legally recognized signatures. Electronic signature include digital signature as well as digitized images of paper-based signature and typed notations. The original Information Technology Act 2000 allowed authentication of electronic records only by affixing digital signatures. It was technology specified and not allowed the use of other technologies for authenticating of electronic records. This approach had inherent limitation. The information technology related technologies are constantly evolving. The new technologies are more dependable with added feature, user friendly and cheaper. The benefits of new technology could not have been reaped by making the IT Act technology specific. This technology specific provision was also not in harmony with the laws of other jurisdiction, that is in other jurisdiction of other countries, and more particular with the law on model law on electronic signature adopted by UNICETRAL vide its resolution on number 56/80 dated in December 2001. So this resolution recommended that all the states be in favorable consider favorable consideration to the said model law on electronic signature. In order to harmonize the IT Act with model law, it became necessary to provide for alternative technology for electronic signature that was done through the Information Technology Amendment Act of 2008. So this was the reason of the 2008 amendment. After the enactment of IT Act, it was amended in 2008 as well as 2017, and this was the reason of the 2008 amendment. The Information Technology Act now gives an option to the subscriber to authenticate his electronic record by electronic signature or electronic authentication technique. The electronic signature means authentication of any electronic record by a subscriber by means of the electronic techniques specified in the second schedule and includes digital signature. The electronic documents can now be authenticated either by digital signature or by any other electronic signature. However, the electronic signature or electronic authentication techniques which are considered must be reliable and specified in the second schedule and can only be used for authentication of the electronic records. The electronic signature or electronic authentication technique shall be considered reliable if the following conditions are met. 1. The signature creation data or the authentication data are within the context in which they are used, linked to the signatory, or as the case may be, the authenticator and to no other person. Now, second one, the signature creation data or the authentication data were at the time of signing under the control of the signatory, or as the case may be, the authenticator and of no other person. 3. Any alteration of the electronic signature made after affixing such signature is detectable. 4. Any alteration to the information made after its authentication by electronic signature is detectable. 5. It fulfills such other conditions which may be prescribed. So, for an electronic authentication technique to be reliable, these 5 conditions are said that this technique, it should be unique or linked to the signatory or the authenticator and not to any other person, and then it while the signing is carried out, this technique or this creation data was under the control of the signatory or the authenticator alone, and if any alteration is made after affixing such signature, that should be easily detectable. Same way, if any alteration of the information is made, that should be easily detectable. So here the creation data or the authentication data, it must be only referred to, there should be a single person identified with that. The source identification should be unique, that should be the signatory or the authenticator, and only that person should have the control over it while it has been signed, and any changes, alteration in the signature should be easily detectable. Same way, any alteration in the information should be easily detectable. And finally, if there any other conditions are prescribed, it should fulfill that too. So if all these conditions are met, then an electronic signature authentication technique is reliable. The electronic signatures, like handwritten signatures, can be forged. It has to be verified whether the signature purported to be affixed by the subscriber really belongs to him. The central government may prescribe the procedure for the purpose of ascertaining whether electronic signature is that of the person by whom it is purported to have been affixed or authenticated. The central government may, by notification in the official gazette, add to or omit any electronic signature or electronic authentication technique and the procedure for affixing such signature from the second schedule. However, no electronic signature or authentication technique shall be specified in the second schedule unless such signature technique is reliable. Law relating to authentication of electronic records by affixing digital signature and electronic signature. So, Chapter 2, Section 3 and 3A of Information Technology Act 2000 deals with the authentication of electronic records by digital signature and electronic signature. Some other sections and rules made under the Information Technology Act 2000 are also related to the authentication of electronic records. By Section 3, Subclause 1, a subscriber may authenticate an electronic record by affixing his digital signature. By Section 3A, Subclause 1, a subscriber may authenticate any electronic record by such electronic signature or electronic authentication technique which is considered reliable and may be specified in the second schedule. The power to include electronic signature or electronic authentication technique and the procedure for affixing such signature in the second schedule is vested with the central government, and this is mentioned in section 3 subclause 4. At present, nothing is included in the second schedule. Thus, for the time being, only digital signature can be affixed to authenticate an electronic record. By section 3 and 3A, only subscribers can authenticate an electronic record by affixing his digital signature or an electronic signature. Section 2 subclause ZG of the Information Technology Act defines the term subscriber. So, subscriber means a person in whose name the electronic signature certificate is issued. Section 2 subclause TB of the Act defines the expression electronic signature certificate. So, electronic signature certificate means an electronic signature certificate issued under section 35 and includes digital signature. So, electronic signature issued under section 35 and subscriber is defined under section 2 subclause ZG, and electronic signature certificate is defined in section 2 subclause TB, and section 2 subclause Q of the Act defines the expression digital signature certificate. So, electronic signature is issued under electronic signature certificate is issued under section 35. Electronic signature certificate is defined under section 2 subclause 2B, whereas digital signature certificate is defined under section 2 subclause Q, and is the certificate issued is also under section 35. Now, section 2 subclause T of the Act defines the expression electronic record. Electronic record means data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. Section 2 subclause TA. Section 2 subclause TA of the Act defines the expression electronic signature. So, electronic signature is defined in section 2 subclause TB, and electronic signature is defined in section 2 subclause TA. Electronic signature means authentication of any electronic record by a subscriber by means of electronic technique specified in the second schedule and includes digital signature. Section 2 subclause P of the Act defines digital signature as follows. So, digital signature certificate is defined in section 2 subclause Q and digital signature in section 2 subclause P. Digital signature means authentication of an electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of section 3. By section 3 subclause 2, the authentication of an electronic record by affixing digital signature shall be effected by the use of asymmetric crypto system and hash function, which envelop and transform the initial record into another electronic record. So, section 3 subclause 2 says that the authentication of an electronic record by affixing digital signature shall be effected by the use of asymmetric crypto system and hash function, which envelop and transform the initial electronic record into another electronic record. Section 2 subclause F of the Act defines the expression asymmetric crypto system. It means a system of a secure key pair consisting of a private key for creating a digital signature and a public key to verify the digital signature, private key for the creation and public key for the verification of the digital signature. Key pair is an asymmetric crypto system, means private key and its mathematically related public key, which are so related that the public key can verify a digital signature created by the private key, and this is discussed under section 2 subclause X. Now, the private key, which is discussed under section 2 subclause ZC, means the key of a key of a key pair used to create a digital signature. Public key, which is discussed under section 2 subclause ZD. So key pair is defined in section 2 subclause X, private key in section 2 subclause ZC, then public key in section 2 subclause ZD. So public key means the key of a key pair used to verify a digital signature and listed in the digital signature certificate. So private key is used to create and public key is used to verify the digital signature. By section 3 subclause 4, the private key and the public key are unique to the subscriber and constitute a functioning key pair. The authentication of an electronic record by affixing digital signature shall be effected by the use of asymmetric crypto system and hash function, which envelops and transforms the initial electronic record into another electronic record. The explanation to section 3 subclause 2 says that for the purpose of this subsection, hash function means an algorithm mapping or translation of one sequence of bits into another, generally smaller set known as hash result, such that an electronic record yields the same hash result every time the algorithm is executed with the same electronic record as its input, making it computationally infeasible to derive or reconstruct the original electronic record from the hash result produced by the algorithm, and that two electronic record can produce the same hash result using the algorithm. So explanation to section 3 subclause 2 defines what a hash function is. Two scenarios used to define hash function. One is that it is an algorithm mapping, and one is that it is a translation of one sequence of bits to another, which is generally a smaller set, which is known as a hash result. Now, what is needed from this hash result is that it should we cannot derive the original message from the hash result, and each time this particular hash result or this electronic record is given to given as input, we get the same hash result. So these two should be met. Now, rule 3 of the Information Technology Certifying Authorities Rules 2000 provides for the manner in which information is to be authenticated by means of a digital signature. A digital signature shall A. be created and verified by cryptography that itself with transforming electronic record into seemingly unintelligible forms and back again. B. Use what is known as public key cryptography, which employs an algorithm using two different but mathematically related keys, one for creation of digital signature or transforming data into seemingly unintelligible form, and another key for verifying digital signature or returning the electronic record to original form. The process termed as hash function shall be used both creation and verification of digital signature. Computer equipment and software utilizing two such keys are often termed as asymmetric cryptography. Rule 4 of the Information Technology Certifying Authorities Rules 2000 provides for the creation of digital signature. So the rule 3 discusses about the manner in which information is to be authenticated by means of digital signature, and rule 4 provides for the creation of digital signature. So rule 4 of the Information Technology Certifying Authorities Rules 2000 provide for the creation of digital signature. In order to assign an electronic record or any other item of information, the signer shall first apply the hash function in the signer software. The hash function shall compute a hash result of standard length which is unique to the electronic record. So the hash result of standard length is unique to the electronic record. Now the signer software transforms this hash result into a digital signature using signer's private key. The resulting digital signature shall be unique to both electronic record and private key used to create it. The digital signature and the digital signature certificate attached to its electronic record shall be stored or transmitted along with its electronic record. Now, by section 3 subclause 3, any person can verify the electronic record by the use of public key of the subscriber. The word verify is defined in section 2 subclause ZH. In relation to digital signature, electronic record or public key, the word verify means to determine two main characters. One is two main conditions. One, the initial electronic record was affixed with the digital signature by the use of private key corresponding to the public key of the subscriber. 2. The initial electronic record is retained intact or has been not altered since such electronic record was affixed with the digital signature. So what are the two things that we need to determine while what does verify imply here is determination of two things. One is that the private key corresponding to the public key of the subscriber was used to create this digital signature, and the second thing is that there has been no alteration in the electronic record after the affix of digital signature. Now, Rule 5 of the Information Technology Certifying Authorities Rules 2000 provide for verification of digital signature. So, Rule 4 was related to creation. Rule 3 was respect to authentication by means of digital signature. Rule 4 was deals with the creation of digital signature, and Rule 5 provides for verification of digital signature. The verification of a digital signature shall be accomplished by computing a new hash result of the original electronic record. So, in the earlier process under creation of digital signature, we said that we initially use the signer software to find the hash result, and the hash result is encrypted using the private key of the subscriber to form a unique digital signature. So here, yet again, for verifying, the hash result of the original electronic document is found, and then by means of hash function used to create the digital original electronic record, by means of hash function used to create original digital signature, and by using the public key. So we encrypt the hash function. While creating, we encrypted the hash result using the private key of the subscriber. So to verify it, we have found we use the same hash function and found the hash result for the original electronic record, and that hash result, when given as an input and using the public key, a new hash result is found, and depending on that, we compare if both the hash results are same. The verifier shall check two things, that is whether the digital signature was created using the corresponding private key. 2. Whether the newly computed hash result matches the original result which was transformed into digital signature. So, the verification software will confirm the digital signature as verified if two conditions are met. Condition 1. The signer's private key was used to digitally sign the electronic record, which is not to be the case if the signer's public key was used to verify the signature, because the signer's public key will verify only a digital signature created with the signer's private key. Now, the condition 2 is that the electronic record was unaltered, which is not to be the case if the hash result computed by the verifier is identical to the hash result extracted from the digital signature during the verification process. So with that, we come to the end of digital signature, the laws relating to it and the procedure relating to it. Now we are going to topics 18, that is secure system, secure electronic record and secure electronic signatures. When an electronic record or message is sent over an open network like the internet, it passes through several computer systems, each owned and operated by different entities. At every stage, the electronic record or message is vulnerable to attack. Similarly, an electronic record available on any computer system can be altered, modified, or altogether changed at much greater ease than the information available on paper-based document. Before relying on any electronic record, one has to ensure about the source of electronic record and that the electronic record has not been improperly altered. The authenticity, integrity, and non repudiation, that is, authenticity, integrity, and non repudiation required in any legal system for a record to form basis of a claim. This can be achieved either by securing system or securing data. So, secure system. This secure system is defined under Section 2ZE of the IT Act. It means computer hardware, software, and procedure that A. are responsibly secure from unauthorized access and misuse. B. provide a reasonable level of reliability and correct operation. C. are reasonably suited to perform the intended function. And the last one, D. adhere to generally accepted security procedures. So, a computer hardware or software and procedure is said to be a secure system in 4 conditions. So, what are the 4 conditions? 1. It should be reasonably secure from unauthorized access and misuse. It shall not allow unauthorized access or misuse. Now, second one, the level of reliability should be reasonable and the correct operation. So, there should be a proper reliability. And the third one is reasonably suited to perform intended function. And the fourth one, it should adhere to the generally accepted security procedures. So these are the 4 conditions to call a hardware or a hardware, software, and procedure as secure system. The 4 conditions are: it should have reasonable security and avoid all unauthorized access and misuse. Second one is that there should be a reasonable level of reliability and correct operations. And third one is reasonable. It should function for the intended function. It should perform well the intended function in a reasonable manner, and it should also comply with or adhere to all the generally accepted security procedure. So these are the 4 conditions to call a system secure system, and it is defined in section 2 subclause ZE. Secure electronic record. Electronic records, as stated above, are prone to unauthorized modification or alteration and even can altogether be changed. In order to prevent an electronic record from such unwanted changes, it has to be secured. So, earlier we discussed about secure system, and now it is about secure electronic record. So, it becomes secured electronic record only when security procedure is applied to it. The security procedure enables it to identify whether the electronic record is that of a purported sender, detects any alteration or errors in the communication, contents or storage of the electronic record since the time it was applied should not be altered, etc. The essential features of a secured record is that it has not been altered in the course of storage. If it has been signed by a secure electronic signature, it will have that character. By section 14 of the Act, where any security procedure has been applied to an electronic record at a specified point of time, then such record shall be deemed to be a secure electronic record from such point of time to the time of verification. This is discussed in section 14. Section 16 empowers the central government to prescribe the security procedures and practices to be followed to secure an electronic record. In exercise of the powers conferred under section 16, the central government has made the Information Technology Security Procedures Rules of 2004. Now, Rule 3 of the Information Technology Security Procedures Rules 2004 says that an electronic record shall be deemed to be a secure electronic record for the purpose of the Act if it has been authenticated by means of a secure digital signature. So, Rule 3 of Information Technology Security Procedure Rules 2004 says that an electronic record shall be deemed to be a secure electronic record for the purpose of the Act if it has been authenticated by means of a secure digital signature.
Now we are moving forward to secure electronic signature or secure digital signature. So from secure system we discussed about secure electronic record, and now we are going to discuss about secure electronic signature or secure digital signature. Like electronic records, electronic signatures can be forged. Anyone having access to electronic signatures of others can impersonate them. To prevent such obnoxious activities, various security procedures can be applied to an electronic signature. By Section 15 of the Act, an electronic signature shall be deemed to be secure electronic signature under two conditions. First condition, the signature creation data, that is the private key of the subscriber, at the time of affixing signature was under the exclusive control of the signatory and no other person. Now the condition 2, the signature creation data was stored and affixed in such exclusive manner as may be prescribed. Further, by Rule 4A, so earlier we discussed about Rule 3 and now we are going to discuss about Rule 4A of the Information Technology Security Procedures Rules of 2004. By this rule, that is 4A, Rule 4A, a digital signature shall be deemed to be a secure digital signature for the purpose of the Act if the following has been applied to. 1. That the smart card or hardware token, as the case may be, with cryptographic module in it is used to create the key pair. That the private key, second one, that the private key used to create the digital signature always remains in the smart card or a hardware token as the case may be. So the cryptographic module can be in a smart card or a hardware token. The first condition is that the smart card or hardware token with the cryptographic module is used to create the key pair, and the private key is always used to create the digital signature is always in the smart card or hardware token and not shared with anyone. Now the third condition, that the hash of the content to be signed is taken from the host system to the smart card or hardware token, and the private key is used to create the digital signature, and signed hash is returned to the host system. So the third condition says that there is a content that is to be signed, and that has a hash. So this hash, the hash and the content is in the host system. The hash alone is given to the smart card or the hardware token, where it is using the private key. The signed hash is produced and returned to the host system. Now the fourth one, that the information contained in the smart card or hardware token, as the case may be, is solely under the control of the person who is purported to have the digital signature. So the smart card or hardware token is holding the private key, so it should be solely under the control of the signatory and no one else. Now the fifth one is that the digital signature can be verified by using the public key listed in the digital certificate issued to that person. So this is a key pair where the hash is converted to signed hash using the private key. The receiver can ensure the authenticity only if the person can retrieve the hash value using the public key of the person. So the public key with corresponding to the private key used to create the signed digital signature. Now the sixth one, that the standard referred to in Rule 6 of the Information Technology Certifying Authorities Rules 2000 have been complied with insofar as they relate to the creation, storage and transmission of digital signature. And finally, the seventh condition, that the digital signature is linked to the electronic record in such a manner that if the electronic record was altered, the digital signature would be invalidated. So this is to ensure that there is no alteration in the electronic record after the sign has been affixed. So that was with topic 18, that is secure system, secure electronic record and secure electronic signature. Further, we have topic 19, that is e-governance, electronic governance, its legal recognition and the delivery of service and service provider, retention of electronic records, audit of electronic records, publication of rules and regulations. So this is a pretty important topic and a wide one. It is a wide topic as well as an important topic. So let's start with e-commerce. Okay. Introduction. One of the main objects that is intended to be achieved by the Information Technology Act 2000 is to facilitate electronic filing of a document with the government agency so as to promote efficient delivery of government service by means of reliable electronic records. It's e-governance and not e-commerce. Sorry about that. It's e-governance. So in other words, the Act aims to facilitate e-governance. The World Bank defines e-governance as the use of information and communication technologies by government agencies to transform relations with citizens, business, and other arms of the government. So this definition is given by the World Bank. E-governance aims with the aid of information and communication technology to simplify the following. 1. The interaction between government and citizens or government and business, that is e-services, to simplify and improve e-services. Now the second one, the internal government operation, that is the e-administration, to simplify and improve e-administration. The third one, the external interaction among the members of the society, that is the e-society. So, e-governance, what are the main aim of e-governance is that with the aid of information and communication technology, the government aims to simplify and improve e-service, e-administration and e-society, and this is the aim of e-governance. E-governance is not only providing information about various activities of the government to its citizen and other organs, but also facilitate its citizens and other organs to communicate with the government. It facilitates the delivery of government service to the citizens through procedural simplicity, speed and convenience. It improves public image of the government by making governance transparent. It would increase the accountability of public servants for their decisions and actions. It has the advantage of improving efficiency and productivity of government with less cost and high speed. The Information Technology Act 2000, with the aim of facilitating e-governance, provides for some legal principles. They are as follows. Legal recognition of electronic records. Section 4 of the Information Technology Act 2000 provides that where any law requires that an information or any other matter shall be in writing or in typewritten or printed form, then, notwithstanding anything contained in such law, such requirements shall be deemed to have been satisfied if such information or matter is rendered or made available in electronic form and accessible so as to be usable for subsequent reference. So what it says is that if in any statute it has mentioned that any information or matter shall be in writing or typewritten form, then it is deemed to have satisfied that condition even if it is in electronic form, if it is accessible to be used in a subsequent reference and with authenticity. The legal requirement that any information be in writing or in the typewritten or printed form shall be met if the information is in electronic form and accessible so as to be usable for subsequent reference. However, the above rule does not apply to the following documents. Thus, in the beginning, in the introduction of internet and electronic records, we also discussed some exceptions, and we discussed where IT Act is not applicable in some scenarios. The same is discussed here. Here, one, it's will, and two, it's negotiable instruments, except in case of electronic check. 3, it is trust and power of attorney. 4, it is contract of disposition of immovable property or any interest in such property. 5, documents of title. And 6, any other document notified by the central government. So the same was discussed when we discussed about the introduction of the Information Technology Act, where such act is not applicable to some of the electronic records, and the same is discussed here too. For the case of e-governance, the IT Act does not apply to these, and thus for e-governance too, these does not apply. That is will, negotiable instrument except electronic check, trust and power of attorney, contract for disposition of immovable property or any interest in such property, document of title, any other documents notified by the central government. Now, in addition to these exceptions, there are certain situations which cannot be either fully covered in Section 4 or in the exception. For instance, by virtue of Section 25 subclause 1 of the Indian Contract Act, a written and registered agreement based on natural love and affection between near relatives is enforceable though there is no consideration. As there is no provision in IT Act providing for registration of documents, such a promise can only be treated as excluded from the operation of Section 4 of the IT Act. That is, gift, a written and registered agreement based on natural love and affection between near relatives is enforceable though there is no consideration. It was discussed in Section 25 subclause 1 of Indian Contract Act. But since IT Act, there is no provision for registration in IT Act, this transaction is excluded from the operation of Section 4 of the IT Act. Now, legal recognition of electronic signature. So this was just now we discussed legal recognition of electronic records, and now we are going to discuss about legal recognition of electronic signature. By Section 5 of the IT Act, where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document shall be signed or bear the signature of any person, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is authenticated by means of electronic signature affixed in such manner as may be prescribed by the central government. So, electronic signature have been given legal recognition by IT Act. These are now as good as handwritten signature on paper. Affixing an electronic signature to an electronic document is now identical in law to placing a handwritten signature on a written document. Thus, Section 5 of the IT Act will cover situations like the one stipulated in Section 25 subclause 3 of the Indian Contract Act, which provides that an agreement made without consideration is void unless it is a promise made in writing and signed by the person to be charged therewith, or by his agent generally or by specifically authorized in that behalf. If this promise is stored in an electronic form with a digital signature affixed, it will be enforced in the same way as if it were a promise recorded on a paper with the handwritten signature of the promiser. Now, use of electronic records and electronic signature in government and its agencies. By Section 6 of the IT Act, where any law provides for the following: 1. The filing of any form, application or any other document with any office, authority, body or agency owned or controlled by the appropriate government in a particular manner. 2. The issue or grant of any license, permit, sanction or approval by whatever name called in a particular manner. 3. the receipt or payment of money in a particular manner, then above these conditions, then notwithstanding anything contained in any law for the time being in force, such a requirement shall be deemed to have been satisfied in such filing, issue, grant, receipt, or payment as the case may be, if effected by means of such electronic form as may be prescribed by the appropriate government. So, this was discussed in Section 6 of the IT Act. The appropriate government may, for the above purpose, prescribe the manner and format in which such electronic records shall be filed, created, or issued. And the other conditions are the manner or method of the payment of any fee or charge for filing, creation, or issue any electronic record shall be prescribed by the appropriate government. In exercise of powers conferred under Section 6, the central government has made the information technology, use of electronic records and digital signature rules of 2004. So far we have come across 3 rules. That is the Information Technology Certifying Authorities rules, then the Security Procedure rules, and now Information Technology Use of Electronic Records and Digital Signatures rules 2004. The Security Procedure rules as well as the Use of Electronic Records and Digital Signature rules both are in 2004, while Digital Signature Authorities rules is 2000. Now, by Rule 3 of the Information Technology Use of Electronic Records and Digital Signature rules 2004, any form of application or any other documents referred to in Clause A of subsection 1 of 6, that is 6 subsection 1 clause A, may be filed with any office, authority, body, or agency owned or controlled by the appropriate government using the software specified by it, and such office, authority, body, or agency shall, while generating such software, take into account the following features of the electronic record, that is lifetime, preservability, accessibility, readability, comprehensibility in respect of linked information, evidentiary value in terms of authenticity and integrity, controlled destructibility, and augmentability. So, what are the features of this electronic record that should be considered by the appropriate government is that 1. Lifetime, 2. Preservability, 3. Accessibility, 4. Readability, 5. Comprehensibility in respect of linked information, 6. Evidentiary value in terms of authenticity and integrity. Now 7. Controlled destructibility, and final one, the 8th one, augmentability. So this was discussed in Rule 3 of Information Technology Use of Electronic Records and Digital Signature rules of 2004. Now by Rule 3, any license, permit, sanction, or approval, whatever name called or referred to in Clause B of subsection 1 of Section 6 of the Act may be issued or granted using the software specified under Rule 3. So, just now we discussed about Section 6 subsection 1 Clause A, where the features of the electronic record is to be considered when the appropriate government is accepting the application in digital form or electronic form, and in Rule 3 itself we also discuss about Section 6 subsection 1 Clause B. So 6.1a and 6.1b both are discussed under Rule 3, and 6.1b discuss about the issue of license, permit, sanction, or approval with respect to in electronic form by using the electronic records and digital signatures. Further, we are going to Rule 5 of the Information Technology Use of Electronic Records and Digital Signature rules of 2004. The payment of receipt of any fee or charge for filing, creation, or issue of any electronic record under Clause A, subsection 2 of Section 6 of the Act may be made in a check in the electronic form. So, explanation to Rule 5 that for the purpose of this rule, a check in the electronic form has a meaning assigned to it in Clause A of Explanation 1 of Section 6 of the Negotiable Instruments Act 1881. So, in Rule 3, we discussed about 6.1a and 6.1b. In Rule 5, we are discussing about 6.2 subsection 2 clause A, 6.2a, where we discuss about the check in electronic form. So, the check in electronic form, it has the same meaning assigned as per the explanation 1 of section 6 clause A, explanation 1 of section 6 in the Negotiable Instruments Act of 1881. So the meaning of check in electronic form and its validity is to be related or read with the section 6 of the negotiable, that is the explanation 1 subclause A of explanation 1 of section 6 of the Negotiable Instruments Act of 1881, and it is dealt by Rule 5 of Information Technology, Use of Electronic Records and Digital Signature Rules, and a check in electronic form is discussed in section 6 subsection 2 clause A of the IT Act. Now, section 6 of the Negotiable Instruments Act 1881 defines check as follows. A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check and a check in electronic form. So it is a bill of exchange and it is specified on a specified banker and it is not payable otherwise on demand, and it shall also include the electronic image of truncated check and a check in electronic form. So explanation 1 clause A says a check in electronic form. This means a check which contains the exact mirror image of a paper check and is generated, written and signed in a secure system, ensuring the minimum safety standard with the use of digital signature and asymmetric crypto system. Now there is a clause B to explanation 1, that is a truncated check. It means a check which is truncated during the course of a clearing cycle, either by the clearing house or by the bank, whether paying or receiving payment immediately on generation of an electronic image for transmission, substituting the further physical movement in the check in writing. Now, the section 6 of the Negotiable Instrument Act has two explanations. We discussed about explanation 1 clause A and clause B. Now explanation 2, that is, for the purpose of this section, the expression clearing house means the clearing house managed by the Reserve Bank of India or a clearing house recognized as such by RBI. That was with respect to Negotiable Instruments Act section 6. By incorporating these provisions, the central government aims to undertake an ambitious program of e-governance. The above provisions alone cannot make e-governance a reality in India. It provides only legal support to e-governance. It requires infrastructure and functional equivalence to make e-governance to take off. Now, delivery of services by service providers. Section 6A. So far we were discussing about section 6 of IT Act under e-governance. Under e-governance we discussed about section 4, section 5 and section 6. And now we are going to section 6A of the IT Act under e-governance. Aims to strengthen e-governance by outsourcing delivery of service to their private agencies. By virtue of Section 6A, the appropriate government may, for efficient delivery of service to the public through electronic means, authorize by orders any service provider to set up, maintain, and upgrade the computerized facilities and to perform such services as may be specified by the notification in the official gazette. The service providers so authorized include any individual, private agency, private company, partnership firm, sole proprietor firm, or any such other body or agency which has been granted permission by the appropriate government to offer services through electronic means in accordance with the public policy governing such service sector. The service provider may also be authorized to collect, retain, and appropriate such service charges as may be prescribed by the appropriate government for the purpose of providing such services from the person availing such services. The government may authorize to collect, retain, and appropriate such service charge notwithstanding the fact that there is no express provision under the Act, rule, regulation, or notification under which the services is provided to collect, retain, and appropriate e-service charges by the service provider. The appropriate government shall, by notification in the official gazette, specify the scale of service charges which may be charged and collected by the the service providers. The government may specify different scale of service charges for different type of services. Section 6A has been carved out for efficient delivery of service to the public through electronic means. Retention of electronic records, and that is discussed in Section 7 subclause 1 of the IT Act. So in respect of E-Governance Act, so far we discussed Section 4, 5, 6, 6A, and now for retention of electronic records we are going to discuss about Section 7 subclause 1 of the Information Technology Act. By Section 7 subclause 1 of the Act, if any law provides that documents, records, or information shall be retained for any specific period, then that requirement shall be deemed to have been satisfied if such documents, records, or information are retained in the electronic form. However, the following conditions are to be satisfied. Here 3 conditions are laid out. 1. The information contained therein remains accessible so as to be usable for a subsequent reference. In other words, it must be as easy to read as a paper document or writing. This may necessitate the provision of appropriate hardware to interpret the stored data. Second one, the electronic record is retained in the format in which it was originally generated, sent, or received. However, this electronic record need not be retained unaltered as long as the information stored accurately reflects the data message as it was sent. You have to note this. This electronic record need not be retained unaltered as long as the information stored accurately reflects the data message as it was sent. Now the third condition, the electronic record carries the details which enable the identification of the origin, destination, date and time of dispatch or receipt. This requirement would not be applicable to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. Now, by Section 7 subclause 2, nothing in this section shall apply to any law that expressly provides for the retention of documents, records, or information in the form of electronic records. Now we have to discuss about the audit of electronic documents. That is also discussed under Section 7 of the IT Act, wherein any law for the time being in force, there is a small provision for audit of there is a provision for audit of documents, records, or information. That provision shall also be applicable for audit of document, records, or information processed and maintained in the electronic form. The auditing of paper-based documents have now been extended to electronic documents also. So that is also discussed. Audit of these electronic records is also discussed in section 7. Now we'll be discussing about publication of rules, regulations, etc. in electronic gazette, and that is discussed in section 8. So under e-governance, we looked into section 4, 5, 6, 6a, 7, 7 clause 1 as well as 7 clause 2, and now with respect to publication of rules and regulations in respect of electronic gazette, we are going to discuss about section 8. By section 8 of the IT Act, where any law provides that a rule, regulation, order, bylaw, notification, or any other matter shall be published in the official gazette, then such requirement shall be deemed to have been met if such order, bylaw, notification, or any other matter is published in the official gazette or electronic gazette, and the date of publication shall be deemed to be the date of the gazette which was published in any form. Now, no right to insist document should be accepted in electronic form. So that is discussed in section 9. So under e-governance, we have come across section 4, 5, 6, 6a, 7 clause 1, 7 clause 2, and 7 as a whole, then 8, and now 9. So here, no right to insist that document should be accepted in electronic form. Section 9 of the IT Act makes it clear that nothing contained in sections 6, 7, and 8 of the Act shall confer a right upon any person to insist that any ministry or department of central government or state government or any authority or body established by or under any law or controlled or founded by central or state government should accept, issue, create, retain, preserve any document in the form of electronic records or effect any monetary transaction in electronic form. So any governmental bodies or ministry or any body under them, they cannot insist that the documents have to be in electronic form to accept, issue, create, retain, and preserve. And this cannot affect any monetary transaction in electronic form. So they cannot insist the use of electronic form. Now, validity of contracts formed through electronic means. Now, this is very important with respect to e-commerce too, which we will discuss later. And here, this is discussed under section 10a. So, we have come across section 4, 5, 6, 6a, 7 clause 1, 7 clause 2, 7 as a whole, 8, 9, and now 10a of IT Act. So section 10a of IT Act, wherein a contract formation, the communication of proposals, the acceptance of proposals, the revocation of proposals and acceptances, as the case may be, are expressed in electronic form or by means of an electronic record. Such contract shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for that purpose. So with that, we come to the end of the e-governance. Under e-governance, we discussed about 3 rules that was brought: the legal recognition of electronic records, the legal recognition of electronic signature, then the usage of electronic records and electronic signature. Then we discussed about what checks in electronic form is, then the delivery of service by service providers, then retention of electronic records, audit of electronic records, publication of rules, regulations, etc. in electronic gazette. And we also discussed that there is no right to insist that the document should be accepted in electronic form. And then lastly, we discussed about validity of contracts formed through electronic means. So that is the topics that was covered in e-governance, and the sections discussed were 4, 5, 6, 6A, 7 as a whole, including 7 clause 1, 7 clause 2, then 8, 9, section 8, section 9, and section 10A. And the rules, we discussed 3 rules here: information technology, certifying authorities rules, and then security procedures rules, and then usage of electronic signature and digital signatures rules. Now with that we come to the end of topic 18, and topic 19 is attribution, acknowledgement, and dispatch of electronic records, or electronic records and e-contracts. So that will be discussed in topic 19, which is also yet again an important one. Validity of contracts formed through electronic means. Section 10A of the IT Act, even if in a contract formation, the communication of proposal, the acceptance of proposal, the revocation of proposal and acceptance, as the case may be, are expressed in electronic form or by means of electronic record, such contract shall not be deemed to be unenforceable solely on the ground that such electronic form or means was used for that purpose. A contract is an agreement enforceable at law. An agreement comes into existence when a proposal of the offerer is accepted by the offeree or the promisee. The proposal and acceptance is to be communicated. The offerer may revoke his proposal, so also the acceptor of a proposal may revoke his acceptance. The Indian Contract Act 1872 provides the law applicable to the communication of proposal, acceptance, revocation, and proposal and acceptance by post. Section 10A of the IT Act make it clear that the communication of proposals, the acceptance of proposals, the revocation of proposals and acceptance are expressed in electronic form or by means of electronic record. The contract aroused out of such communication shall also be enforceable if it is otherwise enforceable. The enforceability of an agreement depends upon various other factors such as competency of parties, free consent, consideration, etc. In Trimex International FZE Limited versus Vedanta Aluminium Limited 2010 case, the offer was made through email specifying the terms and conditions. It was unconditionally accepted and communication of acceptance was made through email. It was held by the Supreme Court that mere absence of a signed formal contract would not affect unconditional acceptance of contract or implementation thereof. So this was discussed in Trimex International FZE Limited versus Vedanta Aluminium Limited in 2010. Attribution of electronic records. By Section 11 of the IT Act, an electronic record shall be attributed to the originator under the following circumstances. 1. If it was sent by the originator himself. 2. If it was sent by a person who had authority to act on behalf of the originator in respect of that electronic record. 3. If it was sent by an information system programmed by or on behalf of the originator to operate automatically. Now, Section 2, subclause ZA defines the term originator. Originator means a person who sends, generates, stores, or transmits any electronic message or causes any electronic message to be sent, generated, stored, or transmitted to any other person, but does not include an intermediary. So, Section 2, subclause ZA defines originator. So, except the intermediary, it includes the person who sends, generates, stores, or transmits electronic message or cause any electronic message to be sent, generated, stored, or transmitted to any other person except the intermediary. So, section 2W defines the term intermediary. Intermediary with respect to any particular electronic record means a person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, and cyber cafes. So all these are intermediary. They receive or store or act on behalf of another person. Now acknowledgement of receipt. This is discussed by section 12 subclause 1, where the originator has not stipulated that the acknowledgement of receipt of electronic record be given in a particular form or by a particular method, and acknowledgement may be given by any communication by the addressee, automated or otherwise, or any contact of the addressee sufficient to indicate to the originator that the electronic record has been received. So this is discussed in 12 subclause 1, section 12 subclause 1. In section 12 subclause 2, where the originator has stipulated that the electronic record shall be binding only on receipt of an acknowledgement of such electronic record by him, then unless acknowledgement has been so received, the electronic record shall be deemed to have been never sent by the originator. Now by section 12 subclause 3, where the originator has not stipulated that the electronic record shall be binding only on receipt of such acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed. If no time has been specified or agreed to within a reasonable time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him, and specifying a reasonable time by which the acknowledgement must be received by him, and if no acknowledgement is received within the aforesaid time limit, he may, after giving notice to the addressee, treat the electronic record as though it has never been sent. Now, in section 2, subclause B defines the term addressee. Addressee means a person who is intended by the originator to receive the electronic record but does not include intermediary. So, an addressee is defined in section 2B. The originator is defined in section 2ZA, and intermediary in section 2W. Now, the acknowledgement of receipt and different scenarios are discussed in section 12 subclause 1, 12 subclause 2, 12 subclause 3. Now, we will be discussing about time and place of dispatch and receipt of electronic record. By section 13 subclause 1, unless otherwise agreed to between the originator and the addressee, the dispatch of an electronic record occurs when it enters a computer resource outside the control of the originator. By section 13 subclause 2, save as otherwise agreed to between the originator and the addressee, the time of receipt of an electronic record shall be determined as follows. A. If the addressee has designated a computer resource for the purpose of receiving electronic record, then receipt occurs at the time when the electronic record enters the designated computer resource. Or, if the electronic record is sent to a computer resource of the addressee that is not the designated computer resource, receipt occurs at the time when the electronic record is retrieved by the addressee. Now B, if the addressee has not designated a computer resource along with specified timings, if any receipt occurs when the electronic record enters the computer resource of the addressee, that will be the time taken. By section 13 subclause 3, save as otherwise agreed to between the originator and the addressee, an electronic record is deemed to be dispatched at the place where the originator has his place of business and is deemed to be received at the place where the addressee has his place of business. Now, by section 13 subclause 4, the provision of subsection 2 shall apply. By section 13 subclause 4, the provision of subsection 2, that is where the time of receipt of an electronic record determination. So by section 13 subclause 4, subsection 2 shall apply, notwithstanding that the place where the computer resource is located may be different from the place where the electronic record is deemed to have been received under subsection 3. Now, by subsection 13 subclause 5 of the 5, for the purpose of this section, A. If the originator or the addressee has more than one place of business, the principal place of business shall be the place of business. B. If the originator or the addressee does not have a place of business, his usual place of residence shall be deemed to be the place of business. C. Usual place of residence in relation to a body corporate means the place where it is registered. So this is regarding the electronic records and e-contracts. So we discussed the validity, which is supported by section 10A, and it has a functional equivalent to the provisions of the Contract Act, Indian Contract Act, and there we discussed case law, Trimax International FSE Limited versus Vedanta Aluminium Limited 2010, where it was a contract agreement entered upon through email. So here Supreme Court held that mere absence of a signed formal contract would not affect unconditional acceptance of a contract or implementation thereof. And with the attributions of electronic record, it was discussed in section 11. Here we discussed about who is an originator, who is an intermediary, and who is an addressee. So an addressee is defined in section 2 subclause B, originator in section 2 subclause ZA, and intermediary in section 2 subclause W. Now acknowledgement of receipt was discussed, and here it was discussed based on section 12 subclause 1, 2, 3, 4, 1, 2 and 3, that is 12 subclause 1, 12 subclause 2 and 12 subclause 3, which discussed about the acknowledgement of receipt. And then we discussed about the time and place of dispatch and receipt of electronic record. Here it was discussed based on section 13.1 subclause 1, 13 subclause 2, 13 subclause 3, 13 subclause 4 and 13 subclause 5. So sections 10A, section 11, section 12, 1, 12 subclause 1, 12 subclause 2, 12 subclause 3, 13 subclause 1, 13 subclause 2, 13 subclause 3, 13 subclause 4 and 13 subclause 5. These are the sections relevant to this topic. Now we will be going to the topic, that is topic number 21. Yes, we will be going to the topic number 21, that is controller of certifying authorities and subscribers. That is the topic. So here this is topic number 21, and here what is discussed is section 2 subclause M of the Act defines the expression controller. So controller is defined in section 2 subclause M. Controller means the controller of certifying authorities. He is appointed by the central government under subsection 1 of section 17 of the Act. So a controller is appointed by the central government under section 17 subsection 1 of the IT Act 2000. Now a certifying authority is defined under Section 2 subclause G. So Section 2 subclause G defines the expression certifying authority. Certifying authority means a person who has been granted a license to issue an electronic signature certificate. Sections 21 to 24 of the Act, 21 to 24 of the Act deals with the granting and rejection of license. So it is defined in 2 subclause G. Certifying authority is defined in 2 subclause G, and it is a person who has been granted a license to issue an electronic signature certificate. The granting and rejection of license is discussed in sections 21 to 24 of the Act. Section 2 subclause ZG defines subscriber. So Section 2 subclause ZG defines subscriber. Subscriber means a person in whose name the electronic signature certificate is issued. So this definition we also studied in with respect to a digital signature. There we discussed who is the subscriber. Now further we'll be discussing powers and functions of controller of certifying authority. Section 17 of the Act deals with the appointment of controller and other officers. Section 17 subclause 1 of the central government may, by notification, by Section 17 subclause 1, the central government may, by notification in the official gazette, appoint a controller of certifying authorities. By the same or subsequent notification, the central government may appoint such number of deputy controllers, assistant controllers, and other officers and employees. The controller shall discharge his functions subject to the general control and directions of the central government. The deputy controllers and the assistant controllers shall perform the function assigned to them by the controller under the general superintendence and control of the controller. One of the important functions in the IT Act is the controller of certifying authorities. One of the important functionaries in the IT Act is the controller of certifying authorities. He acts as a central controlling body. He has been assigned with multiple functions. 1. Granting of license to issue electronic signature certificate. By Section 21 subclause 1 of the Act, any person, that is an individual, company or firm, any person may make an application to the controller who is appointed by the central government under Section 17 subclause 1. Any person may make an application to the controller for a license to issue electronic signature certificate. The application shall be in prescribed form. It shall be accompanied by prescribed documents and payment of fees. The applicant shall have the prescribed qualification, expertise, manpower, financial resources, and other infrastructure facilities which are necessary to issue electronic signature certificate. Rule 8 of the Information Technology Certifying Authorities Rule 2000 prescribes the essential conditions to be satisfied by the applicant. So we have discussed about these rules earlier in digital signature, and there we discussed about Rule 3, Rule 4 and Rule 5. Here we are discussing about Rule 8 of the Information Technology Certifying Authorities Rules of 2000, which prescribes the essential conditions to be satisfied by the applicant. So the controller may, on receipt of an application, after considering the documents accompanying the application and such other factors as he deems fit, grant the license or reject the application. Before rejecting the application, the applicant shall be given a reasonable opportunity of presenting his case. The license shall be valid for a period of 5 years from the date of issue. The license can be renewed. The license shall not be transferable or heritable. The license can be suspended or revoked. So, the license shall be valid only for a period of 5 years, after from the date of issue, after which the license can be renewed, and this license is not transferable or renewable, it is renewable, it cannot be transferred or herited. The license can be suspended or revoked. Now, functions of the controller. So this was regarding granting of license to issue electronic signature certificate. Now, functions of the controller, that is discussed by section 18 of the Act. So a controller is appointed by section 17 subclause 1, and granting of license to issue electronic signature certificate is discussed under section 21 subclause 1. And now functions of the controller is discussed under section 18. By section 18 of the Act, the controller may perform all or any of the following functions. 1. Exercise supervision over the activities of the certifying authorities. 2. Certifying public keys of the certifying authorities. 3. Laying down the standards to be maintained by the certifying authorities. 4. Specifying the qualifications and experience which the employees of the certifying authorities should possess. 5. Specifying the conditions subject to which the certifying authorities shall conduct their business. 6. Specifying the contents of written, printed or visual materials and advertisements that may be distributed or used in respect of electronic signature certificate and the public key. 7. Specifying the form and content of an electronic signature certificate and the key. 8. Specifying the form and manner in which accounts shall be maintained by the certifying authorities. 9. Specifying the terms and conditions subject to which auditors may be appointed by the certifying authorities and the remuneration to be paid to them. Then the next one, 10th one, that is facilitating the establishment of any electronic system by a certifying authority either solely or jointly with other certifying authorities and regulations of such system. 11. Specifying the manner in which the certifying authorities shall conduct their dealings with the subscribers. 12. Resolving any conflict of interest between the certifying authorities and the subscribers. 13. Laying down the duties of the certifying authorities. And 14. Maintaining a database containing the disclosure record of every certifying authority containing such particulars as may be specified by regulations, which shall be accessible to public. Now, the third power is power to recognize foreign certifying authorities. So, this is discussed under section 19 of the Act. The controller of certifying authorities has the power to recognize any certifying authority irrespective of its nationality to certify electronic signature and to issue certificates to that effect. However, before recognizing any foreign certifying authority, the controller has to seek permission from the central government. The IT Act requires that certifying authority should display its license at a conspicuous place in the premises in which it carries out its business. This suggests that the foreign certifying authority may need to have an office in India. The controller has to notify his decision in the official gazette. He may revoke such recognition if he is satisfied that any certifying authority has contravened any of the conditions and restrictions subject to which it was granted recognition. He has to, however, record his reasons in writing and notify his decision of revocation of recognition in the official gazette. The electronic signatures issued by the foreign certifying authorities shall be as valid as electronic signatures issued by the certifying authorities of Indian origin. Power to renew a license. The license issued by the controller to the certifying authority shall remain valid only for a period for which it has been issued. before the expiry of its validity period, the licensee, if he is so desirous, can make application to the controller for renewal of his license. However, this application must be made at least 45 days before the date of expiry period, failing which a late fee prescribed by the government shall have to be paid, which in no case shall be more than 500 rupees. The application for renewal of license shall be made in such form and accompanied by such fee as may be prescribed by the central government. However, the fee so prescribed shall not in any case exceed 5,000 rupees. Power to suspend or revoke license. Section 25 and 26 deals with the suspension and revocation of license. The controller has the power to suspend and, if circumstances demand, revoke the license granted to the certifying authorities to issue electronic signature certificates. However, he cannot directly revoke the license, but has to first place it under suspension pending the completion of an inquiry ordered by him. No license shall be suspended for a period exceeding 10 days unless the certifying authority has been given a reasonable opportunity of showing cause against the proposed suspension. The controller can suspend a license only when he has reasonable cause to believe that there exists any ground which gives him power to revoke the license. He can revoke a license if he, after making such inquiry as he deems fit, is satisfied that a certifying authority 1. While making application for license or renewal of license has made a statement which is incorrect or false in material particulars, or 2. Has failed to comply with the terms and conditions subject to which the license was granted to him, or 3. Has failed to observe standards prescribed by central government for ensuring secrecy and security of the electronic signatures, or 4. Has contravened any provision of this Act, rule, regulation, or order made thereunder. But before taking the decision to revoke the license of a certifying authority, the controller has to give a reasonable opportunity to such certifying authority to show cause against the proposed revocation. The decision of the controller to suspend or revoke the license can be challenged before the Cyber Appellate Tribunal, the jurisdiction of civil court in respect of any suit or proceeding which falls within the jurisdiction of the adjudicating officer or Cyber Appellate Tribunal under IT Act is expressly barred, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under the IT Act. However, the aggrieved licensee can try his luck under the writ jurisdiction either before a High Court or Supreme Court. The certifying authority whose license has been suspended is debarred from issuing electronic signature certificates during the period of suspension. The controller shall publish in his database the notice of his decision of suspension or revocation, as the case may be, of the license of certifying authority. Power to delegate. By Section 27 of the Act, the controller may in writing delegate any of the power which he is empowered to exercise under the IT Act to the deputy controller, assistant controller, or any other officer. Now, power to investigate. By Section 28, the controller himself or any officer authorized by him in his behalf shall have power to investigate any contravention of the provision of this Act, rule, or regulation made thereunder. While making investigation, the controller or any other officer authorized by him shall exercise all the powers of income tax authorities conferred on them under Chapter 13 of the Income Tax Act 1961, with all those limitations laid down under the Act. Now, power to have access to computers and data. By Section 29 of the Act, by the controller or any officer authorized by him as a reasonable cause to suspect that any contravention of the provision of this chapter has been committed. He may himself or any other person authorized by him have access to any computer system, apparatus, data, or any other material connected with such system for the purpose of searching or causing a search to be made for obtaining any information or data contained in or available to such computer system. Any person in charge or otherwise connected with the operation of the computer system, data, apparatus, or material shall be, by order, directed by the controller or any person authorized to provide such reasonable technical and other assistance may be necessary. So this was regarding the powers of the controller. So once again, one is the granting of license to issue electronic signature. The second one, to perform all the functions of the controller. The third one was to power to recognize foreign certifying authorities. Fourth one was to power to renew license. Fifth one, power to suspend or revoke license. And then sixth one is power to delegate. Seventh one was power to investigate. Eighth one, power to have access to computers and data. So 8 powers of the controller was discussed. Now we will be discussing about the functions and duties of the certifying authorities. So far we discussed about the powers of controller, and now we are going to discuss about the function and duties of certifying authorities. So 1. Granting of electronic signature certificate. By section 35 subclause 1, any person may make an application to certifying authority for the issue of electronic signature certificate. It shall be in the prescribed form. The application shall be accompanied by the prescribed fee. The application shall be accompanied by a certification practice statement or a statement containing such particulars that are specified by regulations. On receipt of an application, the certifying authority may, after considering the documents and making necessary inquiries, grant the electronic signature certificate or reject the application. In case the application is rejected, it shall record the reasons in writing. Further, the application shall not be rejected without giving the applicant a reasonable opportunity of showing cause against the proposed rejection. A certifying authority is a trusted body that ascertains the identity of the applicant of the electronic signature certificate and certifies that the public key of a key pair used to create digital signature belongs to that person. The person to whom the certificate is issued is called subscriber. A certifying authority, while issuing a digital signature certificate, shall certify that 1. It has complied with the provisions of the Act and the rules and regulations made thereunder. 2. It has published the certificate and the subscriber has accepted it. 3. The subscriber holds the private key corresponding to the public key listed in the certificate. 4. The subscriber holds a private key which is capable of creating a digital signature. 5. The public key to be listed in the certificate can be used to verify a digital signature affixed by the private key held by the subscriber. 6. The subscriber's public key and private key constitute a functioning pair. 7. The information contained in the certificate is accurate. And 8. It has no knowledge of any material fact which it has included in the certificate would adversely affect the reliability of the representation stated above. Now, after the issue of the certificate, a subscriber cannot be held responsible if the key pair is wrong. Now, the next we will be discussing about suspension of certificate, that is discussed under section 37. So issuance of certificate was discussed under section 35 subclause 1, and then we will be discussing about suspension of certificate, section 37. The certifying authority which has issued a digital certificate may suspend such certificate on receipt of a request to that effect from the subscriber or any person duly authorized to act on his behalf. The certificate can also be suspended if the authority is of opinion that the certificate should be suspended in public interest. However, in such a case, the period of suspension shall not exceed 15 days unless the subscriber is given an opportunity of being heard in the matter. On suspension of certificate, the subscriber shall be communicated of the same. Revocation of certificate. That is discussed in section 38. The certifying authority may revoke the certificate issued by it in the following cases. 1. Where the subscriber or any other person authorized by him makes a request to that effect. Or 2. Upon the death of the subscriber. So we have discussed earlier that this is not transferable or heritable. So upon the death of the subscriber. Or 3. Upon the dissolution of the firm or winding up of the company, where the subscriber is a firm or a company. The certifying authority can revoke the certificate under the following circumstances also. That is, when a material fact represented in the certificate is false or has been concealed. Second one, a requirement for issuance of the certificate was not satisfied. Third, the certifying authority's private key or security system was compromised in a manner materially affecting the certificate's reliability. In these three cases, the subscriber should be given an opportunity to be heard in the matter. On revocation of the certificate, the certifying authority shall communicate the same to the subscriber. If a certificate is suspended or revoked, the certifying authority shall publish notice of such revocation or suspension in the repository specified in the certificate for publication of such notice. Now, this was the first point regarding the function and duty of the certifying authority that dealt with the granting and then suspension and revocation of the electronic signature. Now, the second function or duty is duty to follow certain procedures. By section 30, every certifying authority shall A. Make use of hardware, software and procedures that are secure from intrusions and misuse. B. Provide a reasonable level of reliability in its service which are reasonably suited to perform the intended functions. C. Adhere to the security procedures to ensure that the secrecy and privacy of the electronic signature are assured. D. Be the repository of all electronic signature certificate issued under the Act. The D. Fifth point. Publish information regarding its practices, electronic signature certificates and current status of such certificate. And sixth point is that observe such other standard as may be specified by the regulation. That was discussed under section 30. Now the third duty or function of the certifying authority. So the third duty is duty to ensure compliance of the Act. This is discussed in section 31. By section 31, every certifying authority shall ensure that every person employed or otherwise engaged by it complies in the course of his employment or engagement with the provisions of the Act, rules, regulations or orders made thereunder. Now, the fourth duty is duty to display license. By section 32, every certifying authority shall display its license at a conspicuous place of the premises in which it carries on its business.
Now the fifth duty is duty to surrender license. By section 33, every certifying authority whose license is suspended or revoked shall immediately after such suspension or revocation surrender license to the controller. If the license is not surrendered, the person in whose favor license is issued shall be guilty of an offence and shall be punished with imprisonment, which may extend up to 6 months, or a fine which may extend up to 10,000 rupees, or with both. Now, the sixth duty is duty to disclose. By section 34, subclause 1, every certifying authority shall disclose: 1. Is electronic signature certificate. 2. Any certification practice statement relevant thereto. 3. Notice of revocation or suspension of a certifying authority certificate, if any. 4. Any other fact that materially and adversely affect either the reliability of electronic signature certificate which the authority has issued or the authority's ability to perform its services. Now, we are moving on to the duties of a subscriber. A digital signature certificate, if a digital signature certificate, the public key of which corresponds to the private key of that subscriber, which is to be listed in the digital signal certificate, is accepted by a subscriber, the subscriber shall generate that key pair by applying the security procedure. A subscriber shall be deemed to have accepted a digital signature certificate if he publishes or authorizes the publication of the certificate to one or more persons or in a repository. By accepting a certificate, the subscriber certifies to all who reasonably rely on the information contained in the certificate that he holds the private key corresponding to the public key listed in the certificate and is entitled to hold the same. The representations made by the subscriber to the certifying authority are true, and the information contained in the certificate is true to his knowledge. Every subscriber shall exercise reasonable care to retain control of the private key corresponding to the public key listed in his digital signature certificate and take all the steps to prevent its disclosure. If the private key corresponds to the public key listed in the certificate is compromised, he shall communicate the same to the certifying authority without delay. The subscriber shall be liable till he informs the certifying authority that the private key has been compromised. So that was all with respect to the functions and duties of the controller, certifying authority, and the subscriber. And the next topic will move on to topic number 22, that is the provisions of Information Technology Act 2000 relating to penalty and compensation for access, damage, etc. to computer system, computer network, or computer resources. Or it can be said that the activities that would invite civil liability to pay penalty and compensation under IT Act of 2000. So, Section 43 of the Information Technology Act 2000 declares the activities that would invite liability to pay penalty and compensation. They are discussed as below. So, this Section 43, it should also be read with Section 42 of the IT Act. Now, the first one, access without permission. So, by Section 43, subclause A of the Act, if any person without permission of owner or any other person who is in charge of a computer system, computer network, or computer resource access or secure access to such computer system, or computer network, or computer resource, he shall be liable to pay damages by way of compensation to that person so affected. So the first one is access without permission. Now the second one is downloading data without permission. So, by Section 43, subclause B of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system, computer network, or computer resource downloads, copies, or extracts any data, that is, downloads, copies, or extract any data, computer database, or information from such computer system or computer network, including the information or data held or stored in any removable storage medium, he shall be liable to pay damages by way of compensation to the person so affected. So the second point is downloading data without permission. Now the third point is introducing computer contaminant or computer virus. By Section 43, subclause C of the Act, if any person without permission of owner or any other person who is in charge of it, of a computer, computer system, or computer network, introduces or causes to be introduced any computer contaminant or computer virus into any computer system, or computer network, he shall be liable to pay damages by way of compensation to the person so affected. So point 3 is introducing computer contaminant or computer virus. Now point 4 is damaging computer or computer systems. So by Section 43, subclause D of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system, or computer network damages or causes to be damaged any computer, computer system, or computer network, data, computer database, or any other programs residing in such computer, computer system, or computer network, he shall be liable to pay damages by way of compensation to the person so affected. So the fourth point is damaging computer, computer system, etc. Now the fifth point is disruption of computer, computer system, or computer network. By Section 43, subclause E of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system, or computer network disrupts or causes disruption of any computer, computer system, or computer network, he shall be liable to pay damages by way of compensation to the person so affected. So the fifth point is disruption of computer, computer system, or computer network. The sixth point is denial of access. By Section 43, subclause F of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system, or computer network denies or causes the denial of access to any person authorized to access any computer, computer system, or computer network by any means, he shall be liable to pay damages by way of compensation to the person so affected. So the sixth point is denial of access. Now the seventh point is assistance to facilitate access. By Section 43, subclause G of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system, or computer network provides any assistance to any person to facilitate access to a computer, computer system, or computer network in contravention to the provisions of the Act, rules, and regulations made thereunder, he shall be liable to pay damages by way of compensation to the person so affected. That is the seventh point, assistance to facilitate access. Now the eighth point, charging another person by tampering. By Section 43H of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system, or computer network charges the service availed of by a person to account of another person by tampering with or manipulating any computer, computer system, or computer network, he shall be liable to pay damages by way of compensation to the person so affected. Now the ninth point is destroying information. By Section 43I of the Act, if any person
43 subclause I of the Act, if any person without permission of owner or any other person who is in charge of a computer, the computer system or computer network destroys, deletes, or alters any information residing in a computer resource or diminishes its value or utility or affects it injuriously by any means, he shall be liable to pay damages by way of compensation to person so affected. That is the ninth point, destroying information. It includes destroying, deletion, alteration, diminishing the value or utility or affecting it injuriously. All this is included under destroying of information, point number 9. Now, 10th point is stealing computer source code. By section 43 subclause J of the Act, if any person without permission of owner or any other person who is in charge of a computer, computer system or computer network steals, conceals, destroys or alters or causes any person to steal, conceal, destroy or alter any computer source code used for a computer resource with an intention to cause damage, he shall be liable to pay damages by way of compensation to the person so affected. So the 10th point was stealing computer source code. So these are the 10 activities that will invoke civil liability and civil liability to pay penalty and compensation under IT Act. The 10 points are 1. Access without permission, 2. Downloading data without permission, 3. Introducing computer contaminant or computer virus, 4. Damaging computer and computer system, etc. 5. Disruption of computer system or computer network. 6th one is denial of access. 7th, assistance to facilitate access. 8th one, okay. 7th one is assistance to facilitate access. 8th one is charging another person by tampering. 9th one is destroying information, and 10th one is stealing computer source code. Now we come to the topic number 23, compensation for failure to protect sensitive personal data. So, compensation for failure to protect sensitive personal data. By section 43A of the Act, if the 43 capital A, section 43 capital A of the Act, if a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation to the person so affected. So by section 43A capital A, so what it is said is that if any corporate is possessing or dealing or handling sensitive personal data in its resource and it's a resource on something that the body corporate owns, controls or operates, and by the negligence of this body corporate it or default in practicing reasonable security practices and procedures, if a person has a wrongful loss or wrongful gain, then such body corporate will be liable to pay damages by way of compensation to the person so affected. Now, explanation 1 to section 43 capital A defines the expression body corporate. Body corporate means any company and includes a firm, sole proprietorship or other association of individuals engaged in commercial or professional activities. Explanation 2 to section 43A defines the expression reasonable security practices and procedures. Reasonable security practices and procedures means security practices and procedures designed to protect such information from unauthorized access, damage, use, modification, disclosure or impairment
as may be specified in an agreement between the parties or as may be specified in any law for the time being in force, and in the absence of such agreement or any law, such reasonable security practices and procedures as may be prescribed by the central government in consultation with such professional bodies or association as it may deem fit. Now, explanation 3 to section 43 capital A defines the expression sensitive personal data or information. Sensitive personal data or information means such personal information as may be prescribed by the central government in consultation with such professional bodies or association as it may deem fit. Now, in the exercise of the power conferred by clause OB of subsection 87 with read with section 43A. So 87 subclause OB read with section 43A of IT Act 2000. The central government made the information technology reasonable security practices and procedures and sensitive personal data information rules of 2011. So far we came across 3 other rules, that was regarding information technology, digital certifying authorities rules, then safety procedures rules, and then the usage of electronic signature and digital signature rules. And now we have information technology, reasonable security practices and procedures and sensitive personal data or information rules that came in 2011. By Rule 3 of information technology, reasonable security practices and procedures and sensitive personal data or information rules of 2011, the following personal information are treated as sensitive personal data or information. 1. Password. Password means a secret word or phrase or code or passphrase or secret key or encryption or decryption keys that one uses to gain admittance or access to information. 2. Financial information such as bank account, credit card or debit card or other payment instrument details. 3. Physical, physiological and mental health condition. 4. Sexual orientation. 5. Medical records and history. 6. Biometric information. Biometric means the technologies that measure and analyze human body characteristics such as fingerprints, eye retinas and irises, voice patterns, facial patterns, hand measurements and DNA for authentication purposes. That is discussed in Rule 3. Now, Rule 8 of the Information Technology, Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011 declares what are reasonable security practices and procedures. With that, we come to the end of topic the compensation for failure of protection of sensitive personal data. And the next topic we have is adjudication of claim for compensation. Now, Section 46 of IT Act 2000 provides for adjudication of claim for compensation. If a person is affected or aggrieved by any of the activities stated in Section 43 or 43A of the Act, he may approach adjudicating officer and claim compensation. By Section 46 subclause 1 of the central government, by Section 46 subclause 1, the central government has to appoint any officer not below the rank of a director to the Government of India or an equivalent officer of a state government to be adjudicating officer. The adjudicating officer is empowered to adjudicate whether any person has committed a contravention of the law which renders him liable to pay penalty for compensation.
The adjudicating officer shall have jurisdiction to adjudicate matters in which the claim for injury or damage does not exceed 5 crores. If the claim for injury or damage exceeds rupees 5 crores, the claimant has to approach competent court. The adjudicating officer shall have the powers of a civil court. Before adjudicating a claim for compensation, the adjudicating officer shall give to the person alleged to have committed violation of law a reasonable opportunity for making representation in the matter. If on such inquiry the adjudicating officer is satisfied that the person has committed the contravention, he may impose such penalty or award compensation as he thinks fit. While adjudicating the quantum of compensation, the adjudicating officer shall have due regard to the following factors. 1. The amount of gain of unfair advantage where quantifiable made as a result of the default. 2. The amount of loss caused to any person as a result of the default. 3. The repetitive nature of the default. So the first is the amount of gain of unfair advantage wherever it is quantifiable as the result of a default. If there is a amount of gain of unfair advantage, if it's quantifiable, that will be considered. The amount of loss caused to any person as the result of the default, and the repetitive nature of the default. These three will be considered. Now, appeal to the Cyber Appellate Tribunal. By Section 57 of the Act, a person who is aggrieved by an order of the adjudicating officer can prefer an appeal to a Cyber Appellate Tribunal having jurisdiction in the matter. The appeal is to be preferred within 45 days of the receipt of order. So it is to be noted, the adjudicating officer will have a pecuniary jurisdiction only up to 5 crores, and the adjudicating officer has power conferred by Section 46, whereas the Cyber Appellate Tribunal is discussed, appeal to Cyber Appellate Tribunal is discussed under Section 57, and appeal is to be preferred within 45 days from the date of receipt of order. Now, recovery of penalty. By Section 64 of the Act, a penalty imposed or compensation awarded under the Act, if not paid, shall be recorded as an arrear of land revenue, and license for the electronic signature certificate, as the case may be, shall be suspended till the penalty is paid. Now, compounding of contraventions. By Section 63 of the Act, any contravention under the Act may either before or after the institution of adjudicating proceeding be compounded by the adjudicating officer, subject to such conditions as the adjudicating officer may specify. However, such amount shall not exceed the maximum amount of penalty which may be imposed under the Act for contravention so compounded. If a person commits the same contravention within 3 years after the first contravention, the subsequent contravention cannot be compounded. If any contravention is compounded, no proceeding or further proceeding shall be taken against the person guilty of such contravention in respect of the contravention so compounded. So, with respect to adjudication for claim of compensation, we discussed adjudicating officer, cyber appellate tribunal, recovery of penalty, and compounding of cooperation. So, the claim for compensation with respect to adjudicating officer is discussed in Section 46, and appeal to cyber appellate is discussed in Section 57. Recovery of penalty in Section 64. Compounding of contravention in Section 63. So, with respect to adjudication of claim of compensation, we have Section 46, 57, 64, and 63. And the next topic is Appellate Tribunal. So, Chapter 10, that is Section 48 to 64 of IT Act. So, Chapter 10, Section 48 to 64 of the IT Act 2000 deals with appellate tribunal. In the earlier topic, we discussed that Section 57 deals with appeal to cyber appellate tribunal, and 63 regarding compounding of contravention, and 64 regarding recovery of penalty. So the same is applicable here too with respect to appellate tribunal. Chapter 10, Section 48 to 64 IT Act discuss about appellate tribunal. Chapter 10 was amended by the Finance Act of 2017. So in the introductory part, we already discussed that the IT Act 2000 was amended twice, in 2008 as well as in 2017. We already discussed the need for the 2008 amendment earlier for giving legal recognition, e-governance with respect to e-governance, and now we are here. This chapter 10 was amended by the Finance Act of 2017. By Section 48, Subclause 1 of the Act, the Telecom Dispute Settlement and Appellate Tribunal established under Section 14 of Telecom Regulatory Authority of India Act, TRI Act 1997, shall be appellate tribunal for the purpose of IT Act, and the said appellate tribunal shall have exercised jurisdiction, powers and authority conferred on it by or under the Act. So, by Section 48, Subclause 1 of the Act, Telecom Disputes Settlement and Appellate Tribunal established under Section 14 of TRI Act 1997, that is Telecom Regulatory Authority of India Act 1997, shall be the appellate tribunal for the purpose of the Information Technology Act, and the said appellate tribunal shall have exercised jurisdiction, powers and authority conferred on it by or under the Act. By Section 57, any person aggrieved by an order made by the controller or an adjudicating officer may prefer an appeal to the appellate tribunal. No appeal shall lie to the appellate tribunal from an order made by an adjudicating officer with the consent of the parties. Every appeal shall be filed within a period of 45 days from the date on which a copy of the order is received by the aggrieved person. If there is sufficient cause, the appellate tribunal may condone any delay in preferring an appeal. On receipt of an appeal, the appellate tribunal, after giving parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying, or setting aside the order appealed against. The appellate tribunal shall send a copy of every order made by it to the parties to the appeal and to the concerned controller or adjudicating officer. Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the High Court within 60 days from the date of communication of the decision of order of the tribunal to him on any question of fact or law arising out of such order. If there is sufficient cause, the High Court may condone any delay in preferring an appeal. So here, to the High Court, the appeal shall be filed within 60 days, and to the appellate tribunal, the appeal shall be filed within 45 days. Bar of jurisdiction. By Section 61 of the Act, a civil court shall not have jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating officer or the appellate tribunal is empowered by the Act to determine. Further, no civil court shall grant injunction in respect of any action taken or to be taken by any authority in pursuance of any power conferred by the Act. So that is with respect to appellate tribunal, which is discussed in Chapter 10, Section 48 to 64, and it was amended by Finance Act of 2017. Now, the next topic we have is definition of intermediary along with the liability on intermediary with respect to the IT Act of 2000. So section 2 subclause W defines the term intermediary. Intermediary with respect to any particular electronic record means any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces and cyber cafes. Cyber cafes means any facility from where access to internet is offered by any person in the ordinary course of business to the members of the public. Now, exemption from liability. This is discussed in section 79 subclause 1 of the Act. Exemption from liability. By section 79 subclause 1 of the Act, an intermediary shall not be liable for any third-party information, data or communication link made available or hosted by him. Third-party information means any information dealt with by an intermediary in his capacity as an intermediary. Under the following circumstances, the exemption proviso applies. 1. The function of the intermediary is limited to providing access to a communication system over which information made available by a third party is transmitted or temporarily stored or hosted. 2. The intermediary does not initiate the transmission, select the receiver of the transmission, and select or modify the information contained in the transmission. 3. The intermediary observes due diligence while discharging its duties under the Act and also observes such other prescribed guidelines. Under the following circumstances, the exemption provision does not apply. So, just now we said about the three situations where the exemption applies, and now we are going to discuss about the two situations where the exemption provision does not apply. So, where it does not apply, situation 1, if the intermediary has conspired or abetted or aided or induced, whether by threat or promise or otherwise, in the commission of unlawful act. And the second situation, even after receiving actual knowledge that any information, data or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit unlawful act, the intermediary fails to expeditiously remove or disable access to that material on that resource without vitiating the evidence in any manner. So here we discussed three scenarios where the exemption is applied for intermediary and two situations where exemption is not applied. So where exemption is applied is that the function of intermediary is limited to providing access to a communication system and that per party lies is transmitted and temporarily stored or hosted. Like the intermediary's function is only to provide access and they don't have any active participation. And the second scenario is intermediary does not initiate any transmission or involve in any unlawful activities. And the third one is where intermediary observes due diligence and follows all the prescribed guidelines. So in these three, when all these three conditions are met and then again there is an unlawful activity that took place, then there is an exemption of liability for intermediary. But if the intermediary has conspired or abetted or induced or had the knowledge that an unlawful activity is happening and they did not take any measure to curtail that without vitiating the evidence, then the intermediary will be liable, and there is no exemption to this. So this exemption from liability is discussed under section 79 subclause 1, and intermediary is defined under section 2 subclause W. So the next topic we have is offenses and punishment under the Information Technology Act 2000 or cybercrimes. This is one of the important topic with respect to Information Technology Act and usually asked for essays. So chapter 11 section 65 to 78, chapter 11 section 65 to 78 of the Information Technology Act 2000 deals with the offenses and punishments. 1. Tampering with computer source code. By section 65, whoever knowingly or intentionally conceals, destroys or alters, or intentionally or knowingly causes another to conceal, destroy or alter any computer source code used for a computer, computer program, computer system or computer network when the computer source code is required to be kept or maintained by law for the time being in force shall be punishable with imprisonment up to 3 years and with fine which may extend up to 2 lakh rupees or with both. So tampering with computer source code, that is discussed under section 65. So here what is discussed is conceal, destroy or alter any computer source code, or intentionally or knowingly causing, or does it intentionally. So there is two types, that is knowingly or intentionally conceals, destroys or alters, or causes another to conceal, destroy or alter any computer source code. And what is the punishment? The punishment will be imprisonment up to 3 years or with fine which may extend up to 2 lakh rupees or with both. So this is discussed in section 65. Computer source code means listing of programs, computer commands, design and layout, and program analysis of computer resource. So section 65 deals with tampering with computer source code, and the punishment will be up to imprisonment up to 3 years and with a or with a fine which may be extend up to 2 lakh rupees or with both. Now the second offense is computer related offenses. This is discussed in section 66. By section 66, if any person dishonestly or fraudulently does any act referred to in section 43. So we already discussed about section 43 and 43A earlier. So by section 66, if any person dishonestly or fraudulently does any act referred to in section 43, he shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. The explanation to section 66 says that for the purpose of this section, A, the word dishonestly shall have the meaning assigned to it in section 24 of Indian Penal Code. So dishonestly is defined in section 24 of Indian Penal Code 1860, and the same meaning is applied here. And B, the word fraudulently shall have the same meaning assigned to it section 25 of Indian Penal Code 1860. So in the explanation of section 66, it says that the meaning of dishonestly and fraudulently will be the same as discussed in Indian Penal Code 1860 in section 24 and 25. Now let's look into the definition of the dishonestly and the definition that is given in Indian Penal Code. Dishonestly. Section 24 of the Indian Penal Code defines the word dishonestly as follows: whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that thing dishonestly. If a person has done an act with the intention of causing wrongful gain to one person or wrongful loss to another, he is said to have done that act dishonestly If the following conditions are satisfied, an act of a person can be treated as dishonest. 1. He should have done an act. 2. The act was done with the intention to cause wrongful gain of any property to himself, or the act was done with the intention to cause wrongful loss of property to another person. Third one, the person who has gained the property should not be legally entitled to it, or the person who has lost the property should be legally entitled to it. So if these three conditions are satisfied, then that act is a dishonest act. Now, wrongful gain and wrongful loss. Section 23 of the IPC defines the expression wrongful gain and wrongful loss. Wrongful gain is gain by unlawful means of property to which the person gaining is not legally entitled to. Wrongful loss is the loss by unlawful means of property to which the person losing it is legally entitled. In order to constitute wrongful gain, the following conditions are to be satisfied. 1. A person should gain some property. 2. He should gain the property by unlawful means. 3. He should not be legally entitled to it. Now, in order to constitute wrongful loss, the following conditions are to be satisfied. 1. There should be loss of some property to one person. 2. The loss must be caused by unlawful means. 3. The person suffers loss of property should be legally entitled to it. So, gaining wrongfully and losing wrongfully, Section 23 of the IPC defines the expression clearly. A person is said to gain wrongfully when such person retains wrongfully as well as when such persons acquires wrongfully. So, retains wrongfully and acquires wrongfully. That is gaining wrongfully. A person is said to lose wrongfully when such person is wrongfully kept out of any property as well as when such person is wrongfully deprived of the property. So, a person is said to have gained wrongfully under the following two circumstances, that is, he has wrongfully retained any property or he has wrongfully acquired any property. A person is said to have lost wrongfully under the following two circumstances, that he has wrongfully kept out of any property or he is wrongfully deprived of any property. Now, we also discuss fraudulently. So, that is discussed in section 25 of IPC. A person is said to do a thing fraudulently if he does that thing with the intent to defraud but not otherwise. If the following conditions are satisfied, a person is said to have done an act fraudulently. 1. He should have done an act. 2. He should have the intention to defraud another. 3. The intention should be to defraud another and not otherwise. Now, Section 43 of the Information Technology Act 2000 describes the wrongful acts which would invite liability to pay penalty or compensation. Those acts which would invite liability to pay penalty or compensation are also made punishable under Section 66. On a conjoint reading of the Section 66 and 43, the following acts can be treated as computer-related offences. That is, we discussed 10 of it earlier. The same has been discussed here too. With respect to section 43, we discussed 10 elements. Now, that is access without permission, downloading data without permission, introducing computer contaminant or computer virus, damaging computer system, etc., disruption of computer system or computer network, denial of access, assistance to facilitate access, charging another person by tampering, destroying information, stealing computer source code. So these were the 10 points of civil that 10 acts that invokes a civil liability to pay penalty and compensation that was discussed under section 43A to J, and the same is discussed with respect to section 66, as these offences which invoke civil liability will also be considered as computer related offenses when read with section 66. So section 66 should be read conjointly with section 43. And 43A is related to sensitive personal data. Now, with respect to the third offense we discussed, that the first one we discussed was with respect to section 65, and that was tampering with computer source code. Then the second one was with respect to section 66, that is computer related offenses, which also included has to be read with 43, section 43. So it had 10 offenses which also came under computer related offenses, 43A to 43J. And further, we have the third offense mentioned here is sending offensive messages, that is discussed under section 66A. By section 66A of the Information Technology Act, any person who sends by means of a computer resource or a communication device the following is an offense, that is A, any information that is grossly offensive or has menacing character, or B, any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will, persistently by making use of such computer resource or a communicative devices, sends such information. Now, or there's a third scenario too, that is any electronic mail or electronic email message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or the recipient about the origin of such messages, shall be punishable with imprisonment of a term which may extend to 3 years and with fine. So sending offensive messages discussed under section 66A. Here three kind of messages were discussed, that is an information that is grossly offensive or has menacing character. The second one is an information that the person knows to be false but still he sends it for the purpose of causing annoyance, inconvenience, danger, obstruction, etc. Such message, or any email for the purpose of causing annoyance or inconvenience or to deceive or mislead the addressee. All such messages are considered as offense. Sending such messages are offense, and the punishment will be imprisonment for a term which may extend to 3 years and with fine. So it's and with fine and not or. So the fine and the imprisonment comes together. Previously we saw that it was imprisonment or fine or both, but here it was imprisonment up to 3 years and fine. The term electronic mail and electronic mail message means message or information created or transmitted or received on a computer system, computer resource or communication device, including attachments in text, image, audio, video and other electronic record which may be transmitted with the message. This is explained in the explanation to section 66A. So we have a very famous and important case here, that is Shreya Singhal versus Union of India. That was a criminal writ petition, criminal in nature. So here the Supreme Court struck down section 66A of the Information Technology Act 2000 as unconstitutional, as being violative of fundamental right guaranteed under Article 19(1)(a) of the Constitution of India. So the sending of messages which was discussed in 66A, this was struck down in a decision of 2012, in a 2015 decision, that is Shreya Singhal versus Union of India. It was a writ petition filed in 2012 and decision in 2015. Shreya Singhal versus Union of India. The Supreme Court struck down section 66A of the Information Technology Act 2000 as unconstitutional as being violative of the fundamental right guaranteed under 19(1)(a) of the Constitution of India, that is freedom of speech. Now, the fourth offense discussed here is receiving stolen computer resource or communication device. So, by Section 66B of the Information Technology Act 2000, whoever dishonestly receives or retains any stolen computer resource or communication device, knowing or having reason to believe the same to be stolen computer resource or communication device, shall be punished with the imprisonment of either description for a term which may extend to 3 years or with fine which may extend to 1 lakh rupees or with both. So, receiving a stolen computer resource is discussed in section 66B, and the punishment discussed is imprisonment up to 3 years or with fine which may extend up to 1 lakh rupees or with both. Now, the fifth offense discussed here is identity theft. So, this has been discussed in 66C. Identity theft has been discussed in 66C. So, the first offense we discussed is tampering with computer source code, that is in section 65. Then the second was computer related offense in section 66A. Then section 66 computer related offense is discussed in section 66, and tampering of computer source code in section 65, and the access and in 66A we discussed about sending offensive message, which was struck down in 2015 in a case that was a writ petition of criminal nature that was filed in 2012, Shreya Shankar versus Union of India, saying it is being violative of 19(1)(a), the freedom of speech. And now then we looked into receiving a stolen computer resources and communication device, that is in 66B. And now the fifth offense we are discussing is identity theft in 66C, section 66C. So here, whoever fraudulently or dishonestly make use of electronic signature, password, or any other unique identification feature of any other person shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine which may extend to 1 lakh rupees. So here again we are using imprisonment and fine. So far in all the offenses we discussed, the maximum imprisonment is 3 years, but mostly we have imprisonment or fine or both. But in a previous scenario we saw that it was imprisonment and fine. Now again, in case of identity theft, it is mentioned as imprisonment and fine. Now the next offense, that is the sixth offense, is cheating by personation. So that is discussed in section 66D. Here, whoever by means of any communication device or computer resource cheats by personating shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable with fine which may extend to 1 lakh rupees. So the penalty is the same in 66C and 66D, imprisonment up to 3 years and fine up to 1 lakh rupees. And 66C is about identity theft and 66D is about personation. Now the seventh offense we discuss is violation of privacy. By section 66E of the Information Technology Act, whoever intentionally or knowingly captures, publishes or transmits the image of a private area of any person without his or her consent, under circumstances violating the privacy of that person, shall be punished with imprisonment which may extend to 3 years or with fine not exceeding 2 lakh rupees or both. So the penalty here, imprisonment up to 3 years, or with fine up to 2 lakh rupees, or with both. And violation of privacy is discussed under section 66E. The word transmit means electronically send a visual image with the intent that it be viewed by person or persons. The word capture with respect to an image means to videotape, photograph, film, or record by any means. The word private area means naked or undergarment clad genital, pubic area, buttocks, or female breast. Now, the word publishes means reproduction in the printed or electronic form and making it available for public. The expression under circumstances violating privacy means circumstances in which a person can have a reasonable expectation that 1. He or she could disrobe in privacy without being concerned that an image of his private area was being captured, or 2. Any part of his or private area would not be visible to public regardless of whether that person is in a public or private place. Now the 8th offense we discuss here is cyber terrorism. Here by section 66F, cyber terrorism is dealt in section 66F of the Information Technology Act 2000, prescribes punishment for cyber terrorism. As per section 66F, there are 2 types of cyber terrorism. They are the following. A. Whoever with the intent to threaten the unity, integrity, security, or sovereignty of India, or to strike terror in the people or any section of people. 1. Denies or cause the denial of access to any person authorized to access computer resource, or 2. Attempts to penetrate or access a computer resource without authorization or exceeding authorized access, or 3. Introduces or causing to introduce any computer contaminant, and by means of such conduct causes or is likely to cause death or injuries to personnel, or damage to or destruction of property, or disrupts or knowing that it is likely to cause damage or disruption of supplies or service essential to the life of the commodity, or adversely affect the information stored in the specified under section 70 and 72, commits the offense of cyber terrorism. The expression critical information infrastructure, that is, adversely affects the critical information infrastructure mentioned under the provisions of the Act. So, what does critical information infrastructure mean? The computer resource, the incapacitation or destruction of which shall have debilitating impact on national security, economic, public health, or safety. So, in 66F A, we discussed that whoever with the intent to threaten the unity, integrity, security, or sovereignty of India, or to strike terror, they perform either of the following 3 actions, that is, denies or cause the denial of access to any person authorized to access the computer, or attempts to penetrate or access a computer resource without authorization or exceeding the authorization. And the third scenario, where introduces or causes to introduce any computer contaminant, and as a result of which the following situation occurs, that is, death or injuries to a person's, damage to or destruction of property, disrupts or knowing that it is likely to cause damage or disruption of supplies or services essential to the life of the community, and adversely affect the critical information structure, then that person commits the offense of cyber terrorism. Now, subclause B of 66F. That is, whoever knowingly or intentionally penetrates or accesses a computer resource without authorization or exceeding authorized access, and by means of such conduct obtains access to the following, which are information, data, or computer database that is restricted for a reason of the security of the state or foreign relations, or any restricted information, data, or computer database with reasons to believe that such information, data, computer database so obtained may be used to cause or likely to cause injury to the interest of the sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement of an offense, or to the advantage of any foreign nation, group of individuals, or otherwise. In such scenario, that person also commits the offense of cyber terrorism. So, two scenarios were discussed under 66F of cyber terrorism. A and B. Whoever commits or conspires to commit cyber terrorism shall be punished with the imprisonment, which may extend to imprisonment for life. So this is the one of the maximum penalty that we have come across so far. So far, all other penalties in under the provisions of the IT Act were imprisonment up to 3 years and or with fine. But for 66F cyber terrorism, here the penalty may extend to imprisonment for life. This is the one of the maximum penalty we have come across so far, and the penalty is discussed in section 66F subclause 2. And the two types of cyber terrorism was discussed as in section 66F subclause A and subclause B. Now the ninth type of offense that we are going to discuss is publishing or transmitting obscene material in electronic form. This is discussed in section 67. Whoever publishes or transmits or caused to be published or transmitted in electronic form any material which is lascivious or appeal to the prurient interest, or if its effect is such as to tend to deprave and corrupt persons who are likely, having regard to all relevant circumstances, to hear, see, or hear the matter contained and embodied in it, shall be punished on the first conviction with imprisonment of either description for a term which may extend to 3 years, and with fine which may extend to 5 lakh rupees. And in the event of second or subsequent conviction with imprisonment for either description for a term which may extend to 5 years, and also with fine which may extend up to 10 years. So publishing or transmitting obscene material in electronic form is discussed under section 67, and two modes of penalty or punishment is discussed here. For first conviction, the penalty will extend up to 3 years and with fine which may be up to 5 lakh. And for subsequent conviction or the second conviction, it may extend to imprisonment of 5 years and with fine which may extend up to 10 lakh rupees. Now the 10th offense we are going to discuss is publishing or transmitting material containing sexually explicit act in electronic form. So this is discussed in section 67A of the Act. Whoever publishes or transmits or caused to be published or transmitted in any electronic form any material which contains sexually explicit act or conduct shall be punished on the first conviction with imprisonment of either description for a term which may extend up to 5 years and with fine which may extend up to 10 lakh rupees. And in the event of second or subsequent conviction with imprisonment up to for a description for a term which may extend up to 7 years and also with a fine which may extend to 10 lakh rupees. So the penalty is higher compared to except for 66F, the other previous offences had a smaller penalty compared to section 67 and 67A. In 67, we discussed that the first offender may be punished up to 3 years and with fine of 5 lakhs, and in second or subsequent up to 5 years with fine. And with respect to 67A, that is containing sexually explicit act in electronic form, the penalty is even more higher. That in the first conviction, it may be imprisonment up to 5 years and with fine which may extend up to 10 lakh rupees. In second or subsequent conviction, he may be imprisonment up to 7 years and also the fine is extended up to 10 lakh rupees. Now the 11th offense is child pornography. So here this is discussed in section 67B. This is discussed in section 67B of the Act. Whoever A. publishes or transmits or caused to be published or transmitted material in any electronic form which depicts children engaged in sexually explicit act or conduct, or B. creates text or digital images, collects, seeks, browses, downloads, advertises, promises, exchanges, or distributes material in any electronic form depicting children in obscene or indecent or sexually explicit manner, or C. cultivates, entices, or induces children to online relationship with one or more children for an sexually explicit act or in a manner that may offend a reasonable adult on the computer resource, or D. facilitates abusing children online, or E. records in any electronic form abuse or that of the others pertaining to sexually explicit act with children. Such acts shall be punished in the first conviction with imprisonment of either description for a term which may extend up to 5 years and with fine which may extend to 10 lakh rupees, which is similar to 67A first conviction, and in the second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also with fine that may extend up to 10 lakh rupees. So the penalty in section 67A and 67B are the same. Section 67A deals with sexually explicit act in electronic form. Section 67B deals with sexually explicit act in electronic form with depicting children in it. So the penalty is the same. Now, the proviso to section 67B makes it clear that the provision of section 67, 67A and 67B do not extend to any book, pamphlet, paper, writing, drawing, painting, representation of figure in electronic form, the publication of which is proved to be justified as being for public good on the ground that such book, pamphlet, paper, writing, drawing, painting, representation of figure is in the interest of science, literature, art, or learning, or other objects of general concern, or which is kept or used for bona fide heritage or religious purpose. The explanation to section 67B makes it clear that for the purpose of this section, children means a person who has not completed the age of 18 years. Now, abetment of offences. So we have discussed about 11 kind of offences, and now we are going to discuss about abetment of offences. Now, by section 84B of the Act, whoever abets any offence shall, if the act abetted is committed in consequence of abetment and no express provision is made by the Act for the punishment of such abetment, be punished with the punishment provided for the offence under the Act. Explanation to section 84B says that an act or offence is said to be committed in consequence of abetment when it is committed in consequence of the instigation or in pursuance of the conspiracy or with the aid which constitute the abetment. Attempt to commit offence. By Section 84C of the Act, whoever attempts to commit an offence is punishable by the Act or cause such an offence to be committed, and in such an attempt does any act towards the commission of the offence, shall, where no express provision is made for the punishment of such attempt, be punished with imprisonment of any description provided for the offence, for a term which may extend to 1/2 of the longest term of imprisonment provided for that offence, or with such fine as is provided for the offence, or with both. Now, offences with 3 years imprisonment are bailable. So, we discussed most of the offences were in offences with punishment maximum up to 3 years. So, offences with 3 years of imprisonment are bailable. Section 77B of the Act says, notwithstanding any contained in the CRPC 1973, the offences punishable with imprisonment of 3 years and above shall be cognizable, and the offences punishable with imprisonment of 3 years shall be offences with 3 years shall be bailable. So, except for cyber terrorism or 67, 67A and 67B, the rest of the offences are bailable subject to the conditions. Now, power to investigate offences. Section 77C of the Act says that notwithstanding anything contained in the CRPC 1973, a police officer not below the rank of inspector shall investigate any offence under the Act. So, with respect to offences, we discussed 65, 66, 66A, which was struck down, then 66B, C, D, E, F, then 67, 67A, 67B, and that was with the offences, out of which 67, 67A and 67B had a high penalty, and 66F had the maximum penalty, which is of cyber terrorism. So that was with offences and penalties under IT Act 2000. The next topic we have is cyberspace. William Gibson is sometimes credited with the inventing or popularizing the term by using it in his novel in 1984, Neuromancer. The word cyberspace is usually in many contexts, but it is not always clear what exactly that term describes and what it means. The following definitions are noteworthy. Oxford Dictionary 2009 edition. The space of virtual reality, the notional environment within which the electronic communication occurs. Canada Cyber Security Strategy of 2010. Cyberspace is the electronic world created by interconnected networks of information technology and the information on those networks. It is a global common where more than 1.7 billion people are linked together to exchange ideas, services, and friendship. Cyber Security Strategy for Germany 2011. Cyberspace is the virtual space of all IT systems linked at data level on a global scale. The basis of cyberspace is the Internet as a universal and public accessible connection and transport network, which can be complemented and further expanded by any number of additional data network IT systems in an isolated virtual space are not part of cyberspace. New Zealand Cyber Security Strategy 2011. The global network of interdependent information technology infrastructures, telecommunication networks, and computer processing system in which online communication takes place. United Kingdom, the UK Cyber Security Strategy 2011. Cyberspace is an interactive domain made up of digital networks that is used to store, modify, and communicate information. It includes the internet, but also the other information systems that support our businesses, infrastructure, and services. United States National Security Presidential Directive 54 or Homeland Security Presidential Directive 23 of 2008. Cyberspace is defined as the interdependent network of information technology infrastructures and includes the internet, telecommunications, networks, computer systems, and embedded processors and controllers in critical industries. Common usage of the term also refers to the virtual environment of information and interaction between people. Ministry of Communications and Information Technology, India, defines cyberspace as follows. Cyberspace is a complex environment consisting of interactions between people, software services supported by worldwide distribution of information and communication technology. The term cyberspace is used to denote anything associated with computers, information technology, the internet, and diverse internet culture. It is the electronic medium of computer networks in which online communication takes place. Cyberspace refers to all of the data stored in large computer or network represented as a three-dimensional model through which a virtual reality user can move the realm of electronic communication. It is the notional environment in which communication over computer networks occurs. In other words, it is the notional environment in which digitized information is communicated over computer networks. In effect, cyberspace can be thought of as the interconnection of human beings through computers and telecommunication without regard to physical geography. So that is with the definitions of cyberspace. Now, the next topic, email nuisance, that is spamming, spoofing, and phishing. So, spamming or email spamming. Email spamming refers to sending email to thousands and thousands of users, similar to a chain letter. It is also known as unsolicited bulk email messages or any email messages that is unwanted or unrequested by the recipient. Spam messages are mostly commercial advertising, although chain letters, political mailings, and other forms of non-commercial mailings are often included under the spam categorization. A large portion of spam has also been found to be compromised of advertisements for products of dubious quality and services of questionable legality. There are two types of spam: intentional and unintentional. Intentional spam comes from spammers who are soliciting products or attempting to commit fraud. Unintentional spam originates from the computers that are infected with a virus or worm that activates email distribution process in the background. The virus or worm attempts to send bulk messages from the infected computer without the awareness of the computer owner. Now, denial of service attack. This is an attack by the criminal who floods the bandwidth of victim's network or fills his email box with spam mail, depriving him of the services he is entitled to access or provide. Short for denial of service attack, a type of attack on a network that is designed to bring the network to its knees by flooding it with useless traffic. Spamming is often done deliberately to use network resources. Email spamming may be combined with email spoofing so that it is very difficult to determine the actual originating email address of the sender. Some email systems, example Microsoft Exchange, have the ability to block incoming mail from a specific address. However, because these individuals change their email address frequently, it is difficult to prevent some spam from reaching your email inbox. Now, spoofing or email spoofing. Spoofing is the forgery of an email header so that the message appears to have originated from someone or somewhere other than the actual source. Spoofing is often used by spammers and can be accomplished by changing your from email address. So, email spoofing may occur in different forms, but all have a similar result. A user receives email that appears to have originated from one source when it actually was sent from another source. Email spoofing is often an attempt to trick the user into making a damaging statement or releasing sensitive information such as password. Email spammers often use spoofing in an attempt to get recipients to open and possibly even respond to their solicitations. To send spoofed email, senders insert commands in headers that will alter message information. It is possible to send a message that appears to be from anyone, anywhere, saying whatever the sender wants it to say. Thus, someone could send spoofed email that appears to be from you with a message that you didn't write. Email spoofing refers to email spoofing refers to email that appears to have originated from one source when it is actually sent from another source. Individuals who are sending these email are sending junk email or spam, want to email to appear to be from an email address that may not exist. Thus, the email cannot be traced back to the originator. Sometimes, email spoofing is used for what is known as phishing, which aims to trick the recipient to reveal password or other information. For example, you get an email from what appears to be the passport office, asking you to go to a web page and enter your password or change it to one of their choosing. Now, phishing. Phishing is a special type of spam that is intended to trick you to disclose your personal or account information for the purpose of breaching your account and committing identity theft or fraud. It is done by delivering to you a false email message. The email message appears to come from a legitimate source, for example, your bank, government department, etc. The message may contain a legitimate corporation's logo and appear to be sent from the corporation's email address. The message may ask you to click a link in the message to update your account or run a software program to upgrade your computer. Although the message looks legitimate, it is really trying to compel you to submit your personal and confidential information, which will be used to steal your credentials. Normally, you are asked to enter information such as your name, date of birth, place of birth, bank account number, and bank account PIN, etc. So that is with email spamming, spoofing, and phishing. And then the next topic we have cyber stalking. Stalking or being followed are problems that many people, especially women, are familiar with. Sometimes these problems, harassment or stalking, can occur over the internet. This is known as cyber stalking. Cyber stalking, simply put, is online stalking. It has been defined as the use of technology, particularly the internet, to harass someone. Common characteristics include false accusation, monitoring, threat, identity theft, and data destruction or manipulation. Cyber stalking also includes exploitation of minors, be it sexual or otherwise. The harassment can take place on many forms, but the common denominator is that it's unwanted, often obsessive,
and usually illegal. Cyber stalkers use email, instant messages, phone calls, and other communicative devices to stalk. Whether it takes the form of sexual harassment, inappropriate contact, or just plain annoying attention to your life and your family's activities. A cyber stalker need not leave his home to find or harass his target, and has no fear of physical violence since he knows that he cannot be physically touched in cyberspace. He may be on the other side of the earth, or a neighbor, or even a relative. It could be a former friend or a stranger who wants to bother you and your family in an appropriate manner. A person could be of either sex. Interestingly, it is often perpetrated by strangers, but by someone not by strangers, but by someone you know. Both kind of stalkers, online and offline, have designed to control the victim's life. Majority of the stalkers are the once loved or ex-lovers who then wants to harass the victim because just to satisfy their secret desires. Most of the stalkers are men and victim female. How do the stalkers operate? They collect all personal information about the victim, such as name, family background, telephone numbers of residence and workplace, daily routine of the victim, address of residence and place of work, date of birth, etc. If the stalker is one of the acquaintance of the victim, and he can easily get these information. If stalker is a stranger to victim, he collects the information from the internet resources such as various profiles the victim may have filled in while opening the chat or email account, or while signing an account with some website. The stalker may post this information on any website related to sex service, posing as if the victim is posting this information, and invite the people to call the victim on her telephone number to have sexual services. Stalkers even uses very filthy and obscene language to invite the interested persons. People of all kind from nook and corner of the world who comes across this information start calling the victim at her residence and or at workplace asking for sexual service or relationships. Some stalkers subscribe the email account of the victim to innumerable pornographic and sex sites, because of which victim starts receiving such kind of unsolicited emails. Some stalkers keep on sending repeated emails asking for various kind of favors or threaten the victim. In online stalking, the stalker can make third party to harass the victim. In 2013, the Indian Parliament made amendments to the Indian Penal Code 1860, introducing cyber stalking, Section 354C, as criminal offence. So, under IPC, Section 354C deals with cyber stalking. Stalking has been defined as a man who follows or contacts a woman despite clear indication of disinterest to such contact by the woman, or monitoring of use of internet or electronic communication of a woman. So, who a stalker has been defined as a man who follows or contacts a woman despite clear indication of disinterest to such contact by the woman, or monitoring of use of internet or electronic communication of the woman. A man committing the offense of stalking would be liable for imprisonment up to 3 years for the first offense, and shall also be liable to a fine, and for any subsequent conviction would be liable for imprisonment up to 5 years and with fine. So, cyberstalking is an offense under 354 of IPC. This amendment came in 2013. 2013 Criminal Amendment of IPC. It came as Section 354C, and the penalty is up to 3 years, and for subsequent conviction up to 5 years, both with fine. Now the next topic is voyeurism.
So, by Section 354B of Indian Penal Code, any man who watches or captures the image of a woman engaging in a private act in circumstances where she should usually have the expectation of not being observed either by the perpetrator or by any other person at the behest of the perpetrator, or disseminates such image shall be punished on first conviction with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years. So minimum 1 year and maximum 3 years, and shall also be liable to fine. He shall be punished on a second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years, but which may extend to 7 years. So, in subsequent conviction, minimum is 3 years and maximum is 7 years, and also be liable to fine. Then the next topic we have is hacking or cracking. Hacking in simple term means an illegal intrusion into a computer system and or network. This is an equivalent term to hacking, that is cracking, but from Indian law's perspective, there is no difference between the term hacking and cracking. Every act committed towards breaking into a computer and or network is hacking. Hackers write or use ready-made computer programs to attack the target computer. They decide to destruct, and they get the kick out of such destruction. Some hackers hack for personal monetary gains, such as to stealing the credit card information, transferring money from various bank accounts to their own account, followed by withdrawal of money. They extort money for some corporate giant, threatening him to publish the stolen information which is critical in nature. Government websites are the hot targets for the hackers due to the press coverage it receives. Hackers enjoy the media coverage. Motive behind the crime may be greed, power, publicity, revenge, adventure, or desire to access forbidden information. Now, the next topic we have is cyber defamation. The life of common man has been changed a lot by the invention of the internet. The internet has provided a medium to interact with the people worldwide. It has brought the world closer to every man who has access to it. It has proved to be a repository of the enormous information which a common man could not access easily. It has also given new dimensions to businesses and trade. Social networking, entertainment, shopping, job hunt, recruitment, etc. are now possible via the medium of internet. The widespread use of the internet has always given a new face to the crime and a new medium to the bad elements to commit crime. The crimes that are committed by using the computer as an instrument or a target or a means for perpetuating further crimes falls within the definition of cybercrime. Cyber law is the law that governs the crimes committed within the cyberspace. Cyber defamation is also a cybercrime. The term defamation is used to define the injury that is caused to the reputation of a person in the eyes of a third person. The injury can be done by words, oral or written, or by signs, or by visible representations. The intention of the person making the defamatory statement must be to lower the reputation of the person against whom the statement has been made in the eye of the general public. In India, defamation is recognized as a crime as well as tort. Cyber defamation is a new concept, but the traditional definition of the term defamation is applicable to the cyber defamation as it involves defamation of a person through a new and a virtual medium. Cyber defamation is the publishing of a defamatory material against another person with the help of computers or internet. If someone publishes some defamatory statement about some other person on a website or sent emails containing defamatory material to other persons with the intention to defame the other person about whom the statement has been made, would amount to cyber defamation.
The harm caused to a person by publishing a defamatory statement about him on a website is widespread and irreparable as the information is available to the entire world. Cyber defamation affects the welfare of the community as a whole and not merely of the individual victim. It also has its impact on the economy of a country depending upon the information published and the victim against whom the information has been published. The following are the mediums by which offense of cyber defamation can be committed: World Wide Web, discussion group, intranets, mailing list and bulletin boards, and email. In case of Tata Sons versus Turtle International, Tata Sons versus Turtle International, the Delhi High Court has held that publication is a comprehensive term, embracing all forms and mediums including the internet. So that was held in Tata Sons versus Turtle International. It was the decision of Delhi High Court which held that publication is a comprehensive term embracing all forms and mediums including the internet. There are two broad categories of cases falling under cyber defamation. The first category involves the cases in which the liability is of the primary publishers of the defamatory material, for example, website content providers, email authors, etc. The second category involves the case involving the liability of internet service providers or bulletin board operators. The Indian Penal Code 1860 contains provisions to deal with the menace of cyber defamation. Section 499 of IPC says that whoever by words either spoken or written intended to be read, or by signs or by visible representation makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said to defame that person. The offense of defamation is punishable under section 500 of IPC with a simple imprisonment up to 2 years or fine or both. So it is defined in section 499 and the punishment is when prescribed in section 500 of IPC. Now the next topic we have, that is the last topic, that is jurisdiction in cyberspace. So jurisdiction means the authority which a court has to decide matters that are litigated before it or to take cognizance if matters are presented in a formal way for its decisions. The rapid development of information and communication technologies has revolutionized the business practices and individual practices. Taking the lead in these technologies is the internet. Internet is not only a means of communication and information flow but is also a medium of conducting business. More and more business transactions are on the line, contracts are taking place on the internet. Like every other technology, internet has also brought certain problems with itself, such as computer crimes, breach of contracts done online, issues of pornography due to different moral standards in different countries, etc. The decentralized nature of internet usually brings parties residing in different jurisdictions in contact with each other, due to which court will acquire the authority to try the case in case of a contentious issue always remains a problematic question. Traditional rules relating to jurisdiction and competence incorporate a notion of territoriality, but internet communications are not geographically dependent. The very origin of an email message may be unknown. Website information cannot be confined to a target audience but is disseminated simultaneously to a global market. It may affect individuals in number of jurisdictions, all of which have their own particular local law. This gives rise to enormous challenges. According to the tradition, Indian law, the jurisdiction of civil court is mentioned in the Code of Civil Procedure 1908. A civil court in India
can take cognizance of a civil dispute if the cause of action has either wholly or partly arisen within its territorial jurisdiction. The jurisdiction of criminal courts is discussed in the Indian Penal Code and the Code of Criminal Procedure 1973. By Section 2, Subclause 2 of the IT Act, the Act extends to the whole of India and applies to any offence or contravention committed outside India by any person. By Section 75, Subclause 1, the provisions of the Act shall apply also to any offence or contravention committed outside India by any person, irrespective of his nationality. However, the Act shall apply to an offence or contravention committed outside India by any person only if the act or conduct constituting the offence or contravention involves a computer system, or computer network located in India. Thus, the Indian courts can take cognizance of offence punishable under the Act if the offence involves a computer system, or computer network located in India, even though the offence was committed outside India. Further, the Indian courts can proceed even against a foreigner if the offence or contravention involves a computer system, or computer network located in India. So that is with the cyber law notes of Anil K. Nair sir. This is the entire note. Thank you for listening to this, and I hope this helps everyone, as I feel it very helpful, especially for the last minute study, and to have a basic view of whatever is included and whatever is necessary to go through with respect to the subject and the syllabus. So if there is any suggestions that you have, any feedback you have, please drop a message or do interact. Thank you a lot, everyone. I hope this is helpful for you as it is for me.